Honorable members, good morning. Um,
Good morning, Chair. We can hear you.
you can hear me. Thank you so much.
Morning, Chair.
And welcome. We have a longer day today, I fear, but we are going to get through long before the allocated time. So good morning, honorable members. So today we're going to deal with two more items. The item number one is part of yesterday's discussion, which falls under procurement matters, and that is the famous ICMS system that we dealt with. We're then going to take a break and then deal with that HR environment and the expenditure thereon. So that those are the two issues that we're going to deal with today. Ms. Ibrahim will do on behalf of the team as she has been doing. I think it helps us to keep a rhythm. And so I am going to hand over to her to take us through the section. Thanks very much.
Thank you, Chairperson, and good morning to yourself, all the honourable members and colleagues on the platform. As you indicated, Chair, today we're dealing with the ICMS, or the Integrated Claims Management System. By way of background, the RAF has historically struggled with significant operational and system-related challenges, which affects its ability to process their claims efficiently. And this is well noted in both the Portfolio Committee on Transport and also in previous meetings of this committee. And these challenges were then exacerbated by the fact that the RAP had a disintegrated claims environment that was built on technologically outdated legacy systems. And the claims processing was highly paper-based and relied extensively on manual interventions. Some of that, of course, not entirely the fault of the RAF. As members will recall, the Act itself only made provision for the hand delivery or postal delivery by way of example of claims. So clearly there needs to be some amendment. But in terms of the way in which they themselves were dealing with claims that had arrived at its doorstep, that was also very much paper-based, using manual interventions. And as a result, they were unable to easily process their claims within the statutory required timelines. And so what they did is to sought to transform this claims management process to achieve that goal of settling these claims within 120 days of registration, because otherwise, as we dealt with previously, you end up with litigation in respect of those matters. Another impact about this over-reliance on the manual processes was that it obviously increased the risk of fraud and corruption, because your control environment then becomes vulnerable to errors and manipulation. And the RAF, as I said, was then experiencing increasing legal costs associated with this inadequate management and settlement of claims. And members would have seen that for themselves on previous visits to the RAF offices, where there were complaints about files and file loads of documents simply strewn over office floors and so on. Collectively, these challenges then led to the RAF undergoing their major organizational structure review and the restructuring process, which was initiated in the 2020-2021 financial year under the former CEO, Mr. Letswalo. And the aim there was to transition the fund away from a litigation-heavy operating model to a more customer-centric business operating model. And central to this plan was the introduction of what was termed an integrated claims management system, which was also otherwise informally known as Project Bakamuso. And this involved overhauling how claims were processed by moving from this manual paper intensive workflow to a more digitized, automated platform. So in 2021, they embarked on the implementation of the project as part of its modernization efforts. And according to evidence that we heard from PricewaterhouseCoopers, who were the service providers appointed to deliver the project, the purpose of the project was, one, automation of the highly paper-based and manual claims processing; two, facilitating adequate business and analytical reporting; thirdly, to process claims within the required timelines, and then fourthly, to curb the risk of fraud and corruption, and lastly, then also to curb the increasing legal costs. So the rationale for the project obviously makes perfect sense given the challenges that the RAF was facing. To implement the solution, they issued a request for bid in February of 2021, and it was initially scheduled to close on 26th of March 2021. However, because of reasons raised by prospective bidders, they then extended that closing date to 9 April. They received a total of 14 bids. And of the 14 bidders, ultimately PwC was the only bidder that progressed through all of the evaluation phases and which met the minimum thresholds required at each stage. And they then, of course, emerged as the highest scoring bidder at the conclusion. The RAF then appointed PwC on 21 February 2022, and their job was to implement this ICMS over a period of 5 years at a total contract value of 841.92 million, and that included VAT. The implementation of the system was planned in 2 releases, Release 1 and 2. Release 1 was designed as the minimum viable product, so at an absolute minimum what they needed to provide for the capability to process and pay claims from the point of onboarding. So in other words, from the point that they receive the claim right through to payment. And to enable this functionality, the system was integrated with the existing systems, namely the SAP payment system. Release 2 then was intended to introduce added functionality and other system enhancements. And this included integrations with the Department of Home Affairs to perform mortality checks, and then also with banking institutions to automate the verification of banking details. So that would have also assisted in dealing with issues of fraud. According to the PwC project implementation plan, Release 1 of the system was scheduled to go live during the third quarter of 2023. And following this initial go live, a comprehensive operational and post-implementation support phase was then planned from the fourth quarter of 2023 until the fourth quarter of 2025. And the primary objective of that support period was to ensure that the system was successfully embedded and stabilized within the RAF's operations. Concurrently, planning for Release 2 was initiated, with implementation scheduled between the fourth quarter of 2023 and the second quarter of 2024. The ICMS then comprises 3 core integrated components, and members would have been taken through this in some detail. You'll remember that they showed us on the screen how the system would work, and we also saw some of that when we did the Oversight visit. But the 3 components are Guidewire, which is a core solution that enables and automates the end-to-end claims management process, and then Updraft, which was a legal claims resolution platform that applies accident scenarios and South African case law to determine the liability apportionment. That was now to obviously ensure fairness. And then the Intelligent Digital Platform, which was a data and analytical platform that enables reporting and insights. And that's really just complementary to the system. Essentially, the system was intended to fully digitize the claims process and create a single repository for all case information. In terms of the evidence that the committee heard, there were various public submissions that we received on the alleged failure of the ICMS to deliver on its promised benefits, notwithstanding that there was significant financial investment in the project, obviously running to hundreds of millions of rands. Coupled with reports that we had received from AXA on concerns about delays in the rollout of the system in terms whereof original timelines were not met and the overall reliability of the system was in question. And so this committee sought to get a better understanding of the system and make informed observations and conclusions. So at a cost of 841.92 million, it's obviously one of the biggest spends on the RAF contract register. And this is why the committees pay particular attention to this project. So PwC testified in their capacity as service provider for the project. And the first thing the committee sought to understand from them is how the costing worked, and they testified that the approved project fee was all inclusive. However, the contract allowed for 4 types of variations, and these would have been variations that would have attracted additional costs. And namely, those were approved changes. So if it came to light during the process that a change was needed, if there were changes in law, so if the legal framework had to change, which then in turn necessitates a change on the system, that would attract an additional cost. And then if there were any additional deliverables or services required and any exchange rate fluctuations. The exchange rate fluctuations would be typical of contracts where you are relying on software being procured from a country outside of South Africa. So PwC advised the committee that the total contract variations amounted to 39.42 million. And so the total project budget was then revised to 881.33 million. And they testified that at the time of their appearance before the committee, which was in November 2025, a total of 589.92 million had been invoiced to the RAF, leaving them with a balance of 291.41 million to complete the project. So based on current design assumptions, the project completion status was reported at that point to be at 70%. And what we've done is we've included the slide that they presented to the committee that shows that costing in a little bit more detail. Then the National Treasury Office of the Chief Procurement Officer also presented to the committee on RAF's deviations and variations for the year 2022 to 2025. But in that presentation, they only reflected one variation in relation to the ICMS project amounting to 18.94 million for the continuation of the services. And that variation was reported to the Treasury by the RAF on 13 June 2024. Whereas if you look at the table, you'll see that there were other additional variations that weren't reported. Against this backdrop of escalating costs, the committee then sought to understand whether the RAF has derived value for money in terms of the functionality of the solution and the objectives it intended to achieve. So the AXA also shared their observations, which was made during a walkthrough in the 2024-2025 financial year when they sought to review the project. And the 5 key issues were brought to the attention of the committee by the AXA. Firstly, the rerouting of claims on the system is not working as it's meant to. The rerouting was meant to be achieved via feature call national assignment, which ensures that a claim is not dealt with end-to-end by the same region within which it originates. This feature was intended to prevent any collusion within the processing of the claim. And according to the AXA testimony, if the claim needs to move from pre-assessment to registration, for example, how it is supposed to work is that the routing needed to be done randomly, and it can be in any region. It does not need to be in Joburg if a claim that is captured in Johannesburg. However, what we then identified is that the officer can reroute, and now it is defeating the purpose because the way it was set up like that, it was to prevent fraud. So members will recall that it was explained to us in some detail that the whole purpose of that was to ensure that it isn't the same person's dealing with a file from start to finish, because that would lessen your opportunity to commit fraud in relation to that file. And so it would be moving around the various regional offices, but AXA found that that can be bypassed. Secondly, they further found that users continue to use manual intervention despite the large amount of money developed on an automated system, meaning that the users are not actually using the system as intended. So whether that's because there's not sufficient training or they don't have sufficient tools of trade, whatever the case may be, but not all claim handlers are using the system as intended. And then in respect of the medical assessment stage, AXA noted that there's still a number of manual processes done outside of the system. And when they followed up with management on this, management indicated that it was being de-scoped and they're going to go on a separate tender. And the reason that AXA was provided with was that the medical assessment process is complex and it will need time to be developed separately. So during PwC's appearance before the committee, it expanded on that reason for the de-scoping of the medical assessments. And they explained that whilst the system can gather medical information such as treatment codes, diagnostic codes, the types of injuries, loss of earning information, and details of the medical treatments, it's unable to do a clinical management or determine treatment protocols which are needed for a specific injury. And they advise that it's for this reason that the medical management process was de-scoped from the project, and RAF is considering the procurement of a separate clinical management system that they would then integrate with the ICMS at a later stage. The committee also learned that another functional impediment of the system is the integration with the SAP financial system. And the committee heard from PwC that the RAF only informed PwC in July 2025 that no payments could be made for any claims coming through the system. And that necessitated dual processing because you would need to re-enter data into the SAP system for payments. So in the system then wasn't end to end. And this occurred after the contract of the RAF SAP service provider had been terminated, prompting the RAF then to require assistance from PwC to investigate the cause of the problem, notwithstanding that, of course, PwC was not the RAF service provider for SAP. PwC further advised the committee that the investigation found that the SAP system had been configured incorrectly and that prevented payments from being processed through the system. They were, however, able to assist the RAF to resolve the matter, and payments which were held up, according to them, are now flowing. However, there is a new issue that has since arisen. In that PwC says they've now discovered that remittance advices are not being populated correctly, and they are in the process of assisting the RAF to resolve that matter as well. The committee then also heard from NUMSA, who was the recognized union at the RAF between 2017 and 2024, and they echoed these sentiments that the system does not function as intended. According to them, the system uses preset scenarios and drop-down menus for claim evaluation, which are inflexible. And they elaborated that if a claim does not fit the present scenario, which many of course won't because accident claims vary widely, then staff cannot put in a correct outcome without what they call gaming the system. So in other words, staff merely try to select the closest match, notwithstanding that it may not be accurate, because there is no option for other or any option for them to input their own specific information. They're forced to use this drop-down menu. Effectively, if an injury or circumstances are not part of the listed options, then according to NUMSA, the staff have to choose an incorrect option. Otherwise, the claim is not able to move forward. And then what they intend to do after that is to manually adjust it at a later stage. That's obviously suboptimal. It can lead to errors and inconsistent handling of claims. It also then you need some method of ensuring that the person that was handling it does go back later then to do those corrections. So over and above these issues related to functionality, the AXA also identified a number of governance issues. And Mr. Madondo, who testified on behalf of AXA, noted that the project steering committee, which was a steering committee set up in terms of the agreement, was not meeting in accordance with the project charter, which required them to meet on a monthly basis. And the project milestones were also not clearly defined on the project plan, which could be the reason behind the significant delays in terms of implementation. And then the project budget tracking mechanism was also not clear. However, management advised the AXA that the 841.92 million is now a fixed budget, and therefore delays experienced will not have any impact on that budget. When the committee pressed for assurance that no further cost escalations relating to the system would occur, the interim board confirmed when they appeared before the committee that they don't intend to allow the project cost to exceed the contractual amount, notwithstanding that some contractual variations had already been approved at this stage. The committee then also traversed the concerns relating to the significant implementation challenges and delays, notwithstanding the amount of money that's been invested. And the delays were identified as a project risk by the AXA, who cited that the delayed implementation means that the RAF is also delaying in implementing this objective and getting a return on their investment. And PwC attempted to provide an overview of some of the risks and challenges faced in the delivery of the project. The list is not exhaustive, and we have combined some of them, so they may look slightly different to what you would have seen in the presentation that was done by the service provider. But the first is the adoption of the new system, and stricter controls are now embedded in the system relative to what the legacy environment that RAF claim handlers would have been familiar with. So essentially, whereas in the past an official could apply their own judgment in a process, that judgment is now being determined by the system. Then the throughput of claim statistics in the system are low, mainly due to the low allocation of resources by the RAF, which ring fences employees to work on the system while others work on the legacy environment to clear the backlog. So according to the claim statistics presented, more than 101,000 claims had been processed through the system by October 2025, comprising 54,719 compliant claims and 47,163 non-compliant claims. But notwithstanding the volume of claims processed, the number of claims that had progressed through to the payment process remained relatively low. The evidence suggested that although the system claims processing functionality was operational, the approved stage had become a significant bottleneck, limiting the number of claims progressing through to the final payment stage. Then they also raised the fact that the legacy system, in other words, the way in which the RAF used to do business, still remains because the RAF still has to process this huge backlog. And not all of those backlog claims could be migrated to the solution due to being at different stages in the legacy environment, coupled with stricter controls within the system where data validations would have prevented those claims from being processed further. So you essentially are using a dual system. Shifting focus to project delays, the committee heard evidence from AXA that the initial release date for the project was delayed by a year. It was meant to be released stage 1 in September of 2023, but that release date was then amended to the following year, April 2024. And then July 2024 until release 1 finally went live in September 2024. And that too was limited to the Johannesburg and Pretoria regions. The implementation in coastal regions was done the following year on 24 March 2025. As such, now the release 2 date was subsequently changed to December 2025 because that pushed everything out further then. According to PwC's testimony, key reasons for the delays of release 1 included delays in decisions of and contract for provisioning of environments, understanding of agile delivery methodology and ways of working, stakeholder and user availability, definition of minimal sensible product, changes in requirements, the lawfulness of the RAF1 form, and funeral merits bypass. Release 2 delays were attributed to the embedding of release 1, handover and post go live support, and the RAF stakeholder availability and readiness to agree to priorities for release 2. So given the number of challenges and subsequent delays, the committee then probed the RAF executives on whether they had conducted a feasibility study prior to the implementation of the system. And Mr. Manyasha, who's the suspended head in the office of the CEO, in the Office of the CEO, advised the committee that the RAF had conducted comprehensive benchmarking to identify, assess, and establish mitigation strategies for project complexities, resource constraints, data migration risks, and potential project cost escalations. The committee did find this response to be concerning given the stark difference between a feasibility study and a benchmarking exercise. But Ms. Manyasha assured the committee that a feasibility study of the project was included in part and parcel of the benchmarking. And this response then triggered further probing by the committee on the type of mitigation strategies identified by the RAF, to which Ms. Manyasha then conceded that the mitigation measures identified were inadequate, particularly regarding project resourcing and change management, and that these all contributed to implementation delays. According to her testimony, she said that we do put mitigations in place, but as we move along the project, as a big project that many people in the RAF have not been involved in, we must admit that some of the mitigation that we put are not adequate. And by example, she noted that the resourcing of the project itself, especially from the technical side, the ICT side, was not adequate as they would have expected it to be, and as she, as project leader, would have wanted it to be. Ms. Manyasha further acknowledged that although change management strategies had been implemented, the extent of user resistance to the new system had not been anticipated. So that would be from claim handlers themselves. And she said that as much as they put in change management strategies in place, they did not foresee the resistance at the level at which it came, because it's a big organization and a big project. And we had heard about some of that from the union as well, in terms of staff reaction to the project. Similar to the issues raised by AXA, the committee noted that this demonstrated severe governance and oversight gaps on the part of the RAF. And another grave concern also canvassed by the committee, and something that we deal with in another part of this report in detail, is the disputed RAF 1 form and as the basis for the solution, notwithstanding the ongoing litigation on the validity of that RAF 1 form. So the AXA shared with the committee that it had also raised the same concern during the engagements with the RAF, warning that should the judgment not be in favor of the RAF, then the project could lead to fruitless and wasteful expenditure, because the project was built around the requirements as contained in that disputed RAF 1 form. The committee then sought to ascertain from the RAF officials who appeared in the first week of the inquiry whether they had had any internal discussions regarding the financial risks of the project, and whether they had sought legal advice on implementing a solution premised on this disputed RAF 1 form. And the RAF official responsible for the project, and that would be for technical responsibility, Mr. Kubeka, advised the committee that from a project perspective, no specific legal advice was sought on the matter. And he further shared that the project had a steering committee which had provided guidance to the project team to continue with business as usual while the legal matters around the RAF 1 form were pending. We also know, of course, that that team was not meeting as regularly as they should have. Moreover, he advised the committee that the ICMS project team understood the operational landscape and had built the solution to be agile in the face of changing legislative and legal environments, such that it could easily pivot if required. He noted that the principle was that the core data was captured, which would prevent the need to start from scratch if the process had to change. And the committee heard that it would take approximately 6 to 8 weeks to reconfigure the business processes to comply with a new requirement. The evidence of the PwC official, who is the overall engagement partner of the project, Ms. Gilmore, supported what Mr. Kubeka shared. And she confirmed that the cost of making the changes will not be significant, as only the onboarding stage would be affected. So in other words, what documents are compulsory then to hand in order for the claim to be registered. She further asserted that the RAF 1 form is the current legal form. Therefore, PwC would have to be instructed by the RAF to make the changes based on the outcome of the litigation. So in other words, they utilize what was in force at the time. Notwithstanding this evidence, the RAF and PwC officials were unable to quantify monetary value, what the cost would be with making those changes. And Ms. Gilmore advised that the costs are dependent on the judgment, which will determine what changes would be required, as it may be that not the entire form needs to be changed. So given the exclusionary nature of the RAF 1 form, evidenced by the significant decrease in the number of registered claims, which we deal with in a different part of the report, the committee expressed concerns regarding data management, citing that should the RAF lose the legal challenge, then the 445 plus thousand outstanding claims as at 31 March 2025 could escalate exponentially, as claims currently categorized as non-compliant are not fully stored, but would then become valid and require processing. Subsequent to the conclusion of the committee's hearing, on the RAF inquiry in February 2026. The SCA, being the Supreme Court of Appeal, handed down its judgment in April 2026 on the legality of the form, and the SCA dismissed the RAF's appeal and declared that the 2022 RAF 1 form requirements are unlawful. The court has ordered RAF to revert to the 2008 RAF 1 form, and that development will obviously require further modifications to the ICMS system, and it will result in additional project costs. In terms of chair finding and observations, the implementation of the system has not yet fully achieved its intended objectives. Users have to bypass the system to process claims manually due to poor integration within different levels of the claim process value chain, and this heavily undermines the operational rationale of the system being fully automated, and it leaves the claims process susceptible to fraud and manipulation. So that objectives have certainly not been achieved in full. The committee experienced this lack of functionality firsthand during the oversight visit to the RAF office in Parktown in January of this year, where the committee observed that the system remained largely paper-based and was not functioning effectively. So members would recall that there were a number of members that had names of claimants that they were trying to assist, and when asked various claim handlers to input those names and to give information as to where their claims are in the process, in many cases, that information couldn't be retrieved or it couldn't be accessed. So fundamentally, the system does not support the entire claims value chain, from the reporting of an accident through to the final payment of claims. And therefore, in essence, at present, it's unable to address the RAF's core claims processing challenge. Even the users of the system had complained to members during that oversight visit that the system simply does not work. The RAF did not undertake adequate preparation, implementation, and management of the project. This is evidenced by persistent project challenges, implementation delays, and contract variations, which have resulted in the project costs escalating beyond the approved budget for the project. And although the committee was advised that there is no intention to allocate additional funds, evidence before the committee on how far behind the project is from achieving its objectives suggests that the RAF will most likely need to allocate additional funds for the completion, likely through further additional contract variations. The poor implementation and functionality of the system have affected the annual performance targets of the RAF, resulting in audit findings being raised by the Axis, such as the failure of the system to achieve timely payment within the 120-day target, with an average of only 4 out of every 10 completed claims being paid. And that's primarily due to the SAP integration issue. This has consequently negatively impacted on the lived experiences of claimants who are awaiting finalization of their claims. Over and above the ICMS objective of facilitating the timely payments of claims, which it's failed to do, another key objective of the system was the reduction of legal costs. However, contrary to this, evidence before the committee suggests that the system being built on the disputed RAF 1 form has led to increased costs given the legal consequences and the excessive legal disputes. Further, the decision to design the system around the legally contested and rigid RAF 1 form has resulted in many claims being classified as non-compliant, is extremely flawed and negligent. The fact that RAF management made this decision without applying itself to the legal uncertainties that exist and the impact that an adverse ruling against the RAF would have on their already strained financial position is indicative of poor oversight and leadership within the RAF, both at management level all the way up to the board. Accordingly, the committee notes the SCA ruling handed down in April 2026, which ultimately reopens RAF claims which were previously rejected under the exclusionary RAF 1 form. And it preserves them from prescription, which may force the RAF to recognize a magnitude of liabilities that have until now remained off its books, because the RAF simply turned a blind eye to those claims. The committee anticipated this outcome and has repeatedly warned the RAF of this eventuality and its dire associated consequences. So if members go back to the recordings of those meetings, you will see that there was quite a bit of discussion on that point in particular. The committee notes the publication then of a RAF notice in the media on 28th July 2026, which states that pursuant to the judgment, claims lodged from 6 May 2022 onwards will be accepted for reprocessing. The notice further provides that such submissions will not be prejudiced in terms of prescription up until 30 September 2026 and will retain their original submission date. So in other words, notwithstanding that they were rejected, if they were submitted prior to this date, the RAF will now accept a reprocessing of that claim and a resubmission of that claim. The waiver, however, does not apply to new claims that were never submitted. So in other words, if you had a situation, members, whereby somebody was in an accident, wanted to submit a claim, they then get a copy of this RAF1 form, or they're perhaps assisted by an attorney, and they're unable then to gather all that documentation in terms of that disputed RAF1 form and then take the decision, well, we're not in a position to submit it as yet. We're perhaps going to wait to see what comes out in terms of the litigation or whatever the case may be. Then unfortunately, those persons will not be able to resubmit if the prescription period has been reached already. The committee has asked for some clarity on this notice, because our understanding and our reading of the notice, it appears to be unfair and unlawful, because what it effectively does is it reduces the statutory prescription period in certain cases. So by way of example, a victim of a hit and run claim has 2 years in which to claim. And I've taken the committee through how those prescription periods work in one of the earlier sections of the report. So if you've been involved in a hit and run incident, and let's say, for example, that incident occurred on 1 January 2025, that would mean that in law you have until 31 December 2027 to lodge a claim. However, if the claimant had already lodged their claim under the disputed RAF1 form, and that claim was rejected, then the way in which that notice is drafted, it means that the claimant must lodge their claim now by 30 September 2026. So they must resend that claim in by that date, i.e. 15 months prior to the expiration of the actual prescription period. The committee is further concerned that the notice was only published on 28 July 2026, and claimants are being given a mere 2 months by which to make their resubmissions. And this time period is unreasonable, and the arrangements don't take into account that claimants may have practical difficulties lodging a claim within that period, including financial obstacles. As I said in the beginning, claimants still have to send their claims via post or to physically deliver those claims. And obviously that has a cost impact in some cases, as people had said to us outside the RAF offices that they need to take days off from work to be able to actually physically go to the RAF office and submit their claims, or wait for family members to assist and so on. So if that notice, as we understanding it, is saying what we think it says, and as I've indicated, we have asked the RAF for clarity, we still haven't received that clarity, then it is certainly reflective of a disconnect between RAF management and the people that it's meant to serve. That short time period will result, as the committee feared, in an influx of claims, and it's doubtful whether the RAF has the capacity to deal with this influx given resource constraints. It will create an additional burden on staff, and it's likely rather to result in additional litigation where matters are not attended to timelessly, because again, you now have that 120-day period. And this in turn will lead to additional wasted expenditure. As indicated during our sessions with the RAF, they were unable to advise the committee on what plans were being put in place to physically deal with this influx of claims, which the committee was of the view was inevitable given the manner in which the litigation was proceeding. Chairperson, if the RAF responds and indicates that we have misunderstood the notice, then certainly we will rework the last 2 findings. However, based on a pure and simple reading of that claim, that's certainly our understanding. And we think that if we've now alerted them to this issue and they decide then to change it, that it really will be a turnaround rather than our interpretation of how that notice is drafted. Thank you, Chairperson. That brings me to the end of the section on the ICMS system.
Thank you very much, Ms. Ibrahim, and thank you to the colleagues who helped put this together. My own observation that I think we should record is that I don't think we mentioned that, I think the system is needed. Perhaps we need to state that a system like this, as intended at least, is needed. And it's going to resolve, when implemented, it's going to resolve a lot of the issues that over the years Parliament has found on oversight, where there is a significant paperwork, boxes are all over, people can't find the files, people have to submit and resubmit and so on. But I also want to alert members, therefore, to a need to amend the Act, because the Act forces upon the RAF a manual process, in that you can send your claim via a registered mail, or you need to turn up physically and deliver a piece of paper, which means somebody needs to scan those documents and so on, which I think is unnecessary. If those documents can be electronically submitted and filed on the system, it would assist greatly in the processing of the claims themselves, at least in speeding up the processing of the claims, whether those claims are accepted or rejected. One. The second thing is that there are some features of the system which appear to be helpful. As it was described to us, it would bring some consistency into how claims are adjudicated, because there is case law. So if somebody loses 3 fingers, and is 3 fingers at the end of sort of from your little finger to the middle finger, you lose all of those 3. The system would be able to look at what the awards previously have been for somebody who is 15 years old, in high school, etc., and therefore what the determination was, so that the Road Accident Fund can make an offer that is fair. This would address an issue that the member spoke about. If you recall, it was then, there was an observation that a child from Mamelodi won't get the same as a child from Waterkloof. But when the system is looking simply at the child and the age at which they are, the nature of the injuries, the clinical care they would need, etc., the system would read into that without, hopefully, any inherent bias, but certainly it would go some way towards eliminating some of the biases and so on. So I don't need to go through all of this, but I think we need to affirm that the original idea by management at the time, and management subsequently to continue with the system, is valid. So that's the one set of inputs. The other is that I also think that we might need to ask the RAF to tell us what the escalations have been. I am not aware of a single IT project where you don't discover problems during implementation and therefore it has cost implications. I observed the board saying that there wouldn't be any cost escalations, but there's always something you discover that you did not know, because you can't talk to everybody before scoping the project. So maybe we need to invite that information as well. But having said that, let me provide an opportunity to the members to make some comments. Okay, I recognize Honorable Atkinson. I don't see any other hand for now, so let me hand over to you, Honorable Atkinson. And then Honorable Skosana thereafter.
Thank you very much, Chair. Sorry, excuse me. And thank you very much to Ms. Ibrahim and her team, all the people that have been involved in the production of this report. It's another excellent submission. So thank you very much for all the hard work that's gone into that. So the issue I actually want to mention was not so much about today, but there's actually a little bit of a holdover from yesterday with regards to the security contract. And it's just a question I'd like to pose. So when the report was written or when the letter sent to Mr. Letwada, we were discussing, I think you mentioned that initially the amount put aside for security was about 450,000 a year, which you thought was maybe not enough. I think maybe that's the wrong question to ask. I think what the question that we should be asking is, was security actually even necessary at all? And I'll tell you why I'm saying that is that it's come to light that apparently Mr. Letwada was the first CEO of the Red Action Fund ever to get security. And that Eugene Watson, who was his predecessor, he was the CEO of the Road Accident Fund at the time that the RABS bill was being debated and brought to Parliament. Everything was probably under far greater threat than Mr. Letwada was, but actually never had any security. So I think the question that we should be asking is, what changed that Mr. Letwada uniquely required security when no other CEO of the Road Accident Fund ever did, even though the circumstances in which they operated were potentially more dangerous than those that Mr. Letwada operated? I do think it's a good idea to pose that question directly to Mr. Letwada, and I do think it's something that should actually be investigated in the report. So rather than looking at the actual amounts and whether they were right or not, the question we should be asking is, why was it necessary when it never did? That's just something that really should have been put out yesterday. But I do ask, obviously, we can put that onto the record, and those questions are asked as well. With regards to today's presentation, I'm very happy with what's been put across there. And as you rightly said, what we do need is a system that has no inherent bias. I do think that obviously that's the direction we need to move. So I'm very happy with the reports that came out today. Thank you very much.
Thanks very much, Honorable Atkinson. I will deal with your first point at the end. I've noted it. Thank you. It's Honorable Skosana, then it will be Honorable Neil May and Honorable Kubeka in that order.
Yeah, no, thank you very much, and good morning to everyone in the meeting. And we appreciate the presentation from our technical team. Indeed, it's quite a very comprehensive presentation that encompasses a number of matters that were brought to our attention during the inquiry. And I agree with you, Chair, that indeed there is a need for an integrated system to deal with handling, processing, and the general management of claims. Because you can't have such a big institution that deals with claims without an integrated system that tells you where you start, where you go, and then where you are supposed to end, and who is responsible for what at what period. So a need for a system is definitely there. And I think for the REF management and the board to agree on establishing a system, this integrated claim management system, I think it was a noble idea. However, I think it's evident that the system is not working as expected, because if this system was working as expected, we shouldn't be having all these challenges that we are having in relation to the handling and processing of claims. So the system need to be looked at, need to be improved to an extent that is able to respond to all the challenges that the RF is faced with in relation to matters of handling the claim. And of course, I also agree that this issue of paper-based approach, it also needs to be looked at. I think maybe we need to canvass that with the Portfolio Committee on Transport, the Minister of Transport, look at changing the legislation in relation to that. I mean, which institution in this day and age it still work on paper-based approach that you must physically go to an office with papers, with physical papers, and then those papers then must be stored there in boxes, in big files, in cabinets, and all that. I think that thing needs to be looked at. We need to find a way to move with technology and allow a situation where people are able to email and do whatever, able to go to the website and lodge their claims, put their information there, so as to cut time and allow people to submit claims while they are also doing with their other responsibilities. People don't have to take time from work, spend a week every day going to RAF offices and sit on long queues just for their claims to be lodged or to be submitted. And the issue of the disputed Ref 1 form, when you look at it, you would see that this Ref 1 form, with its approach of saying before a claim can be lodged, all the supporting documents must be there. You can see that this thing was actually intended to reduce the liability on the part of RAF, because previously you needed just the minimal information that you have, maybe just to prove that there was an accident, and then you can then lodge a claim. Then at a later stage, you would then go and source the other documents from doctors and to prove that and that. But now, if you, as it was done previously, it means after you have lodged the claim, then RAF incur a liability. Because when they calculate their liability, they must then estimate that perhaps this person, this claim may cost so much. So it impacts on their liability. So the reason that they are doing this, you can see that they want to reduce their liability on the part of RAF, because before you get all the other supporting documents, you can't lodge a claim. It means then you must go up and down with your claim. At some point, if you're not lucky, the claim may be prescribed in your hands. You might find that when you go there to lodge, when you finally get all the required documents, because those documents, they don't come free. You need money to go to specialists and that and that. So at some point, if you are not lucky, the claim will prescribe in your hands. The day you are able to get money and get all the required source documents, when you go and lodge it, it shall have already prescribed, so you can no longer lodge that particular claim. So you can see that the intention was to say, let's reduce the number of people who are submitting claims. Let's have as little as possible number of people who are submitting claims, of which it's wrong. So I think that's why the court decided that no, this Ref 1 form is invalid and it should be set aside. You see, so I think it's a matter that it need to be corrected, making sure that people are able to, with the little information that they have, they are able to lodge a claim. Then they will get the other supporting documents while their claim has been lodged and registered. And then if they are unable to get the other document, then it's another story. But a person should be able to, as early as possible, with the minimal information that the person has, should be able to lodge a claim with the RAF. Thank you very much, Chair.
Thank you very much, Honorable Skosana. All noted. Thank you very much. Honorable Neil May.
Good morning, Chairperson. Good morning to my colleagues present. Good morning to Ms. Abraham and your team. Again, a very comprehensive and well-captured report. It was very easy reading and very well understood. So therefore, I'm going to concur with you, Chairperson, and with Honourable Skosana, that the original decision by management was valid. I think that was one of the areas, and to move away from the paper-based systems. I think we all agree on that. I think now the challenge is to make sure that that system becomes operational. I agree with the RA1 form that Honourable Skosana was speaking. And Chair, I also wanted to mention that I also agreed that a child from Dansani and a child from Ganubi would, with the system, would be able to determine without discrimination the same treatment. I think that was very important. The cost escalations, I think we do need to invite those to get the cost escalations from when we last interrogated the interim board. Chair, the timeframes that you mentioned on the notice, I agree with you, is not sufficient. And then coming to the Act, I think this is where we can make a difference, Chair, is that we need to be able to make motivation and areas where the Act needs to be changed. And I think, now that the post office is not operational it is barely operational, that one would need to include courier services and email. But at the same time, we need to, once the whole report is put together, we must then be able to say on one particular page, we as a committee would look at that and say, these are the areas in the Act that we think needs to be amended. Other than that, a very well captured report. Thank you, Chairperson.
Thank you very much, Honorable Nelmay. On well noted as well. Honorable Kubeka.
Thank you, Chair, and good morning, colleagues. I know, Chair, for me, I think I've just got one question, Chair. And I think this is a question that I would be posing for all of us here as SCOPA. In that when the court ruled against the RAF with the RAF 1 form, do we know what the liability is, or what the liability will be for the Road Accident Fund at the end of this financial year? And once after all of the claims that were rejected and all of those that had prescribed were now added to whatever it is that the RAF that now needs to pay. Do we know what that figure is? And I'm asking this such that we try and understand how viable the Road Accident Fund will be once those liabilities are added. Because I think as things stand right now, the Road Accident Fund has been regarded as something that is not, I think the AG has said that they don't see the RAF functioning as a going concern anymore, given their liabilities. Now, with the added liabilities that will come from that decision by the courts to rule against the RAF 1 form, do we know what the position of the Road Accident Fund will be with the new liabilities? And I think that question may just come up somewhere along the line where, while we are busy looking into the Road Accident Fund, I'm sure someone will ask us, a journalist or someone, to say, guys, but have you not looked at what is the consequence of that decision by the court on the Road Accident Fund? And what is our take on that as a committee? That would be my only question, Chair. And then that Kupega that they're talking about, Chair, I'm not related to them. I don't know them. That Kupega there, unlike Maduna and Maduna Security, we're not sure there, Chair. Thank you.
Thanks, Honorable Kupeka. He also had an earring. I think he had an earring or two, but he was a lovely.
Clearly that one is not.
He was a lovely
We don't know
fellow.
We don't know
He
that
was a
one, Chair.
lovely fellow. No, thank you very much, Honorable Member. So on the first one, Honorable Atkinson, I think there are two things. The first is I suppose the question that you raised about whether we think any security measures were needed at all. The issue of Mr. Modise or Mr. Watson and Mr. Modise was actually canvassed in the committee. We got that background. I think Mr. Modise had just a driver, and Mr. Watson was driving himself, if I remember correctly. But also threats arise at different points in time. What we did not do was to get an independent assessment of the report itself that informed the board's decision. In my recollection, that report did recommend some security measures. So that is the one thing. And I don't know if we are able to make a determination here. One, and secondly, whether the board, this current board, can make an assessment of a previous board decision in that way, because it's got so many subjective factors, right? I think what we do know is that there was a board resolution. The board resolution set out a parameters for the security. There was an amount, and then there was a determination in terms of personnel. The amount itself appeared to have not been informed by the requirement in terms of security, in terms of the number of security personnel, because they would all be paid some of the lowest wages at the Road Accident Fund, because as Mr. Msiza and Mr. Lihumo explained, that the people take shifts. One drives, and one is the one who is actually the close protection officer, and then they take shifts again. So when you do that, you end up with about 3 people in total. And the difficulty with that is that you can't make all of them fit into 480,000. That on its own kicked off a chain of events that resulted in expenditure outside of the resolution of the board. So I think what we must do then is to capture your representations in the report. In any case, I just think it will be difficult to reach a definitive conclusion, having not canvassed the issue in substance during the actual inquiry itself. So that's my view, but we'll capture your views in the report, as we will everybody else and everybody in summary. The second point was raised by Honorable Kubeka. So there are 2 approaches to this. If you recall, when we were at the Road Accident Fund itself, and when the board came to the committee, they said that they have agreed on a way forward on the accounting policy with the National Treasury that will result in an actuarial calculation of the liability itself. And this judgment would cause them to revise the assumptions in that actuarial valuation. So we therefore should ask them, for the purposes of this report, and this is something the Secretariat should note, that what is that revised actuarial valuation, one. Secondly, what the actual liability is. So there's a set of questions that accrue from that. One is, how many claims do they anticipate will be revived as a consequence of this? What the value of those claims do they anticipate it is going to be, etc., so that they can give the committee a number. What is clear, however, is that the Road Accident Fund remains chronically underfunded, and that's one of the things we are going to have to deal with in the report itself, and make some recommendations in terms of what the portfolio committee and the minister need to get into, together with the Ministry of Finance, in order to resolve on this. Some of it may be legislative, and other may be policy in terms of what people are entitled to. So I suggest that we deal with it in that way. But in response to your input, we in the letter that we're sending to the Road Accident Fund at the end of this week, we then add this question so that we get very specific information. In fact, in line with this, we'll also ask the same question of the National Treasury, so that the report captures the parties involved in this. So, Honorable Atkinson and Honorable Kubeka, that's my response. I don't know if there's anything more that you need to raise, but I want to suggest that we move on to the next one, but as we did yesterday, and because sorry, Honorable Atkinson.
No, Chair, thanks. I just want to say that I'm happy. Thank you for your response.
Okay.
I'm happy with that.
Okay, no, thank you very much. So can I suggest that we take that break? The next one is over 30 pages long, so it's gonna take some time. So can I suggest that it's now 10:41, that we get back at 10:55? Would that be okay? And then we'll continue until we finish.
That's fine, Chair.
Thank you. 10:55.
100%, Chair.
Thank you. Honorable members, good morning. Welcome back. Ms. Ibrahim, are you ready?
Yes, Chairperson. Chairperson, we're now moving to a new section of the report, and this is on the governance and human resource matters. This is obviously cross-cutting in nature because, as members are aware, there were governance and HR issues that cropped up from almost every witness that's appeared before us. So some of it, of course, would have to be read in tandem with our findings in other sections of the report. But by way of background, Chairperson, during the public participation process, and indeed this continues up until today, the committee's received various submissions relating to our parameter on governance and human resource matters. And the matters contained within the submissions have resulted in significant financial implications for the RAF and have highlighted alleged irregular disciplinary processes and governance weaknesses, which in turn call into question board accountability and oversight. And Chair, at this point, I just pause to say that while SCOPA has focused on the financial and governance implications, we are dealing with real people. It's a sensitive matter. There's been a number of submissions, whistleblower messages sent to either myself personally, in some cases even to members, to yourself, where staff make all sorts of allegations that unfortunately don't fall within the purview of the committee. But it certainly is a sensitive matter, and members should take that into regard when dealing with the section. So the committee heard that following the appointment of Mr. Letswalo as acting CEO in September of 2019, a concerning trend emerged of specialists being appointed in that office, and that began in May of 2020, despite the positions not being provided for in the organizational structure at the time. It then went on to seem that these specialists were allegedly parachuted into critical positions. And moreover, it was alleged that the appointment of the specialists were not done in compliance with policies and standard operating procedures of the RAF. The committee further heard that following the RAF's 2020-2021 organizational structure review, or OSR process, which culminated in the reduction of positions, many general managers were pushed out of their positions and their contracts were either not renewed or disciplinary charges were taken against them without merit. Evidence before the committee also showed that notwithstanding the RAF's new organogram, and that organogram obviously was a result of the OSR process, several critical posts remain vacant, creating a long-term reliance on acting appointments, which has inadvertently left essential functions without permanent leadership. This has created instability, blurred accountability, and weakened the RAF's ability to execute its mandate. In addition, contrary to prior assurances given to the committee by management, the hearings revealed, and in fact, even prior to that, that Mr. Letswalo had not been vetted by the State Security Agency and that the security vetting of several executive officials remained incomplete. Other evidence before the committee in relation to HR matters deal with these suspensions for extended periods, and in most instances, these prolonged suspensions resulted in a termination of employment. The committee also heard that the RAF makes use of external lawyers for these labour-related matters, and that even in instances where the Labour Court has ordered that affected employees be reinstated, the RAF has allegedly failed to comply. So on that note, Chair, we continue to get whistleblower reports around these issues with people saying that they're trying to report for duty and so on, but the RAF isn't complying. We'll deal first with the appointment of specialists. The summary of the evidence is as follows. The committee heard from Ms. Mpho Manyasha, the suspended head in the office of the CEO, and she testified that approximately 3 months after Mr. Letswalo's secondment as acting CEO to the RAF, he identified capability gaps in several key functional areas, and these included finance, supply chain, and ICT. And according to her, he concluded that specialist expertise were required within his office to provide technical independent advice and then also to liaise with those divisions to help him gain a better understanding of the organization's operations in these functional areas. Following this, Mr. Ian Burrell, the former acting chief corporate support officer, testified that HR then received an instruction from the Office of the CEO to establish 7 specialist positions. And Mr. Burrell informed the committee that the instruction was communicated to him by the then Chief Human Capital Officer, Ms. Lerato Petlele, who together with Mr. Letswalo requested that these positions be created. And he explained that the specialist positions would report directly to the Office of the CEO, and the purpose was to support Mr. Letswalo during the organizational transition by assessing the RAF's existing capabilities, evaluating its readiness for transformation, and supporting the organization's broader transformation journey. So these 7 specialist positions were then subsequently created and approved in accordance with the delegations of power and authority framework, and they were established as fixed-term contracts for a period of 3 years. And this evidence is corroborated by what Ms. Manyasha had indicated to the committee. On the actual recruitment of the specialists, Mr. Burrell testified that HR developed job profiles for each of the 7 positions, and these job profiles were then signed off and approved by the Office of the CEO, after which they were evaluated and graded for salary levels by an external service provider, being the firm Deloitte. He then further informed the committee that once that grading process had been completed, the actual recruitment process commenced. But due to the specialist nature of the positions and the prevailing COVID-19 conditions, the RAF applied the provisions of its recruitment policy that permitted the outsourcing of recruitment for scarce and specialist skills. So consequently, they then outsourced it to an external recruitment agency rather than doing it in-house. In his testimony, he explained that the recruitment agency had to do the recruitment within prescribed procedures, and this included advertising the positions, conducting background and qualification verification checks, including managed integrity evaluation screenings, and they would facilitate the recruitment process as a whole. And then upon completion of these processes, an interview panel was then constituted to interview and assess the candidates for appointment. According to other evidence before the committee, the recruitment and appointment of the specialists occurred in successive phases, and this is covered in some detail in the affidavit of Mr. Victor Songelwa, the former General Manager for Finance. And he explained that the first tranche of specialists commenced duty in May of 2020, and they comprise the Senior Finance Specialist, the Treasury Specialist, and the SCM Specialist, so all finance-based. The second tranche was then appointed in June of 2020 and included a communication specialist and a senior change specialist. And then lastly, in July 2020, a re-engineering specialist was brought in, followed by an ICT specialist and a security specialist, who would have been Mr. Msiza, as we discussed yesterday. Several witnesses who appeared before the committee raised concerns that a number of the specialists that were appointed had established personal or professional relationships with Mr. Letswalo prior to them being appointed at the RAF. And to unpack this, the committee probed on whether the specialists appointed to the Office of the CEO had disclosed any pre-existing personal or professional relationships with Mr. Letswalo or any other executives of the RAF during the recruitment and appointment process. And in response, Ms. Manyasha testified that to the best of her knowledge, the specialists whose interviews she participated in had indeed declared their prior knowledge of knowing Mr. Letswalo. At this point of the interaction, Ms. Manyasha shared with the committee on her own volition that Mr. Letswalo had preferred to headhunt the individuals he wanted for those specialist positions. And according to her, that headhunting could not be done because at the time the RAF policy did not have or did not make provision for headhunting. Therefore, the positions had to be advertised and the people went through interviews and competency assessments, and they were then appointed. And according to her, Mr. Letswalo had already identified certain individuals whom he wished to recruit as specialists. And when probed further on who those individuals were, Ms. Manyasha responded to say that she could recall Mr. Modiba, Mr. Peter Malele, and Ms. Beauty Mabusela. And the committee notes, of course, that all three of those persons were ultimately appointed as specialists. The committee then sought clarity on whether the recruitment process had merely been a formal exercise to tick a box, in other words, to comply with the RAF policy, which didn't provide for headhunting. And Ms. Manyasha then testified that the CEO, again, she said, would have preferably wanted to headhunt people. So her understanding is that in other areas, headhunting is not prohibited. It was just that at the RAF at the time, it was not allowed, and therefore the only way you could headhunt, you could still headhunt, she said, but you still needed to interview at least 2 people for a position. So this was a headhunting process, essentially. And she wasn't really questioned further on that, but I think essentially what she was trying to say is that you're using an agency. That agency can, of course, then go into the market, invite people to apply for the post. But at the end of the day, you still needed to go through a competitive process where you had at least 2 people competing for the post. At this point, the committee then sought to examine the circumstances surrounding the appointment of specialists and the subsequent assumption of key roles within the RAF, and that would have been other key roles other than what they were appointed for. And in this regard, the committee heard oral testimony from some of the specialists, namely Ms. Mabusela, Mr. Modiba, and Mr. Msiza. I'll start with Ms. Mabusela. She joined the RAF as a senior finance specialist in the office of Mr. Letswalo, and she testified that she had a long-standing personal and professional relationship with him prior to joining the RAF. Members will recall that she indicated that they had met through a mutual friend during the 2010 World Cup, during which she was introduced to him as a chartered accountant, and their professional relationship developed when he then later informed her of a vacancy of a board position at the Road Traffic Management Corporation, where he was acting CEO at the time. She applied for that board vacancy and was appointed as a board member, as well as the chairperson then of the Audit and Risk Committee, and she served in that position between October 2011 and October 2014. She then testified that in October 2019, so some years later, Mr. Letswalo informed her that he was appointed as the acting CEO at the RAF, and he inquired from her as to whether she was in the market, meaning the job market, to which she responded positively, indicating that her current contract was due to expire and it was unlikely to be renewed. She then said that some months later, at the beginning of the following year, 2020, Mr. Letswalo let her know that the RAF was recruiting a finance specialist and that they were specifically looking for a chartered accountant for the role, and he encouraged her to apply, which she did, and she was then subsequently appointed to that role on 1st of May 2020. Within weeks of joining the RAF, Mr. Letswalo then informed her of his decision to appoint her as acting CFO. And according to her evidence, he explained that he was dissatisfied with the performance of the then incumbent acting CFO, Mr. Songelwa. And he believed that she possessed the necessary skills to assume the role. So this is a matter that we deal with in quite some detail in the section on the change in accounting policy. So according to Ms. Mabusela, then following her appointment as acting CFO, she was tasked with reviewing that accounting policy, and she subsequently led the review process that ultimately culminated in the RAF board approving the voluntary change in the policy during the 2020-2021 financial year. She then also testified that she resigned from the RAF with immediate effect in May 2021, and the circumstances surrounding her resignation are covered in that section of the report dealing with the change in accounting policy. But members may recall it had to do with the way in which she felt that she wasn't treated properly during a meeting and wasn't allowed to speak, and that ultimately led to her resignation. In particular, the committee formed the view from Ms. Mabusela's evidence that she did not appear to demonstrate an adequate understanding of the statutory and governance framework governing the development and adoption of accounting policies, including the respective roles of management, the board, external advisors, and the Accounting Standards Board. And of course, the chair had spent quite quite some time with Mabusela on those legal prescripts dealing with the change in the accounting policy. The next specialist, Mr. Modiba, he joined the RAF on 4 May 2020, and he was appointed in the position of Senior Treasury Specialist. And prior to joining the RAF, he was at the City of Johannesburg, where, according to allegations presented to the committee by the SIU, he resigned while facing 12 counts of serious financial misconduct. And notwithstanding a confirmation of these allegations through correspondence dated 22 April 2025 from the City of Johannesburg to the committee, Mr. Modiba maintained during his testimony that the allegations were unfounded as the charges against him were withdrawn. And in defense of that, he provided the committee with a copy of an unsigned draft settlement agreement, which, according to him, was not executed because of the COVID-19 pandemic. According to the city, however, the separation was not by mutual agreement, although Mr. Modiba had proposed same, and it was their intention to proceed with disciplinary processes. But of course, a person that has resigned from the position cannot be subjected to internal disciplinary processes, and that would have led to a stoppage in that matter. When probed on his prior relationship with Mr. Litswalo, he testified that he had met him around 2000 or 2001 through professional interactions in the financial sector. He worked at the Treasury Unit at Absa Bank, and Mr. Litswalo worked at the South African Reserve Bank at the time. And he said that they were not friends, and he had only maybe encountered him twice after those initial interactions, and they hadn't maintained contact. He further testified that after seeking employment following his suspension in the City of Johannesburg, he obtained Mr. Litswalo's contact details through a mutual acquaintance to inquire about opportunities at the RAF, having heard through a placement agency that there was a vacancy. And he testified that Mr. Litswalo confirmed that that vacancy existed, told him about the post, after which he then put his application in via the agent. Approximately 2 months after joining as a Treasury Specialist, where his mandate was to identify the drivers of high short-term liabilities and the lack of appropriately matched assets, he was then appointed as Acting General Manager Treasury with effect from July 2020. So this was a position that did not exist on the RAF's approved organizational structure at the time. And when he was probed on the matter, he indicated that HR would be better placed to explain as it related to human resource processes. However, he offered an analogy that, similar to his appointment as a Treasury Specialist, which was not linked to an existing position on the structure, the same rationale could have been applied to his acting appointment. He also testified that where Mr. Litswalo identified operational gaps or weaknesses requiring immediate attention, he could assign an individual to lead a function even in the absence of a formally established post on the structure. So following the RAF's organizational structure review, which they implemented in May 2022, they established an investment division, and Mr. Modiba was seconded to act as the Chief Investment Officer. And he acted in that position until he was suspended in June 2025. And that suspension was in relation to allegations that he didn't, at the time of his appointment, disclose the circumstances surrounding his departure from the city. A critical department such as the actuarial department, which ordinarily fell under the finance division, was moved to this newly created investment division. And the committee noted with concern the establishment of the division and its accompanying CIO position within the RAF, given the existence of a treasury function, which was responsible for managing the organization's cash resources and the statutory framework governing the investment of excess public funds. So again, this is a matter that the committee dealt with in some detail prior to the beginning of the inquiry to understand what the rationale was for having a chief investment officer, given that there was the treasury function, and also that they don't actively invest public funds. The committee therefore sought to ascertain from Mr. Modiba what his role in fact was, and He was specifically asked about whether the RAF had an investment portfolio, and he categorically responded it does not. And in trying to understand what the purpose and genesis of the structure was, he conceded that the investment division lacked a back, middle, and front office, but stated that they were busy with those processes in an organic approach. So, in other words, that this office, whatever it was meant to do, was still being developed. He testified that the CIO position was not established solely to manage investments, but explained that the function comprised two core areas, namely asset management and liability management, with liability management constituting the primary focus due to the RAF's financial position. He confirmed, however, that the RAF had not made any investments during his tenure, and explained that the RAF operated on a net deficit basis and therefore didn't have surplus funds available to invest in any event. It should be noted that his appointment fell squarely within the period that the RAF had intended to secure a credit facility to settle the outstanding settled claims that were requested but not yet paid at the time. And that debt restructuring, which we also deal with in another part of the report, was to the tune of between 15 billion and 20 billion, and it was approved by the board in April 2020, subject to certain conditions, including at the time National Treasury approval. And in his capacity as acting general manager of Treasury, he was then assigned the responsibility to run with that debt restructuring project with a target to secure the debt facility by 31 March 2021. As we indicated earlier in the report, that debt restructuring could be attributed as one of the catalysts for the RAF implementing the change in accounting policy, which ultimately, as we know, resulted in an understatement of the RAF's liabilities and what appeared then to be an improved balance sheet compared to previous years. Moving on to Mr. Stephen Caesar, the security specialist. He was seconded as a specialist security officer on 1 June 2021. And prior to joining the RAF, he testified that he served as deputy security manager at the Road Traffic Management Corporation, where, as I indicated, Mr. Litswalo was previously the acting CEO. And he explained that following Mr. Litswalo's appointment then to PRASA, he was headhunted following security threats made against Mr. Litswalo at PRASA. And he indicated that Ms. Mpho Manyasha, who was also at PRASA at the time, then contacted him regarding that recruitment process. He testified that he was recruited at that time to provide close protection services while also performing security management functions. He further testified that while acting as senior manager at PRASA, he was then seconded to the RAF. And Ms. Manyasha confirmed that Mr. Litswalo had requested her to contact Mr. Caesar regarding his recruitment to PRASA and then subsequently regarding his availability to assist the RAF on secondment. So it happened that both of these officials had moved together with Mr. Litswalo. It also emerged that Mr. Caesar and Mr. Litswalo had a poultry business together, which was called Everything Chicken Holdings. It was a company registered in 2020, and himself and Mr. Litswalo were listed as the sole directors. But according to him, that business venture never materialized, and he did disclose that when he joined the RAF initially. Upon his secondment to the RAF, Mr. Msiza testified that his role as security officer was to assist with restructuring of the RAF security function and also realigning the security environment in line with the minimum information security standards and the minimum physical security standards. And upon his arrival, he reported to the then acting chief operating officer, Ms. Rambauli, who informed him that the RAF lacked the internal capacity to deal with security matters and required his assistance in strengthening the security function. He testified that following his arrival, he engaged with senior security officials to obtain an understanding of the security environment, and these engagements led him to conclude that the security function was not aligned with MIS, prompting him then to question the existing reporting arrangements and implementation of the security principles as prescribed in MIS. The committee then heard evidence from Mr. Lehomo, the former National Security Manager, and Mr. Mshlanga, the former Manager for Physical Security. And they indicated that following the arrival of Mr. Msiza at the RAF, he exercised oversight over the entire security function despite the existence of an incumbent national security manager. So essentially that he then takes over Mr. Lehomo's role. Mr. Msiza subsequently became responsible for all matters relating to Mr. Letswalo's close protection arrangements, which then resulted in those costs ballooning relative to the approved fringe benefit as discussed yesterday. On 1 July 2024, Mr. Msiza was then appointed as a senior manager security following the finalization of the RAF's new security structure. And the committee concerningly heard testimony from Mr. Lehomo that restructuring process resulted in his position of National Security Manager being regraded to a new post called Senior Manager Security, and that the position was initially advertised with a bachelor's degree as the minimum qualification. However, shortly after it was advertised, he and Mr. Mshlanga were suspended, following which the position was then re-advertised with a downgraded requirement of a diploma as the minimum qualification. Mr. Lehomo further testified that the timing of the suspensions prevented him and Mr. Mshlanga from participating in the recruitment process, notwithstanding that they would have been qualified. It bears mentioning also that Mr. Lehomo holds an NQF level 9 qualification. So even in terms of the original advert that required a bachelor's degree, he would have been able to apply. Mr. Burrell confirmed that the qualification requirements contained in the job profile had been lowered prior to Mr. Msiza's application and subsequent appointment in the role. And he testified that although the requirements had been reduced, he was not able to provide a reason for that change between those two adverts. When questioned by the committee whether he was aware that the position had been re-advertised, Mr. Msiza testified that he did not know the reason for the re-advertisement or why the qualification requirements had been lowered. He further testified that the re-advertised position required only an NQF level 6, and he recalled, subject to correction, that the initial advert had required an NQF level 7 or 8. When it was put to him by the committee that he would not have qualified under the initial advertisement because he held an NQF level 6, Mr. Msiza agreed. So following the testimony provided by the three specialists, the committee then examined the governance arrangements surrounding these posts and sought clarity on how these roles interacted with existing line management structures. Mr. Burrell explained that in terms of the formal organizational structure, line managers remained responsible for directing the work of staff within their respective departments. However, he acknowledged that specialists, although located within the office of the CEO, were often mandated by Mr. Letswalo to undertake work within operational departments. And according to him, specialists could be assigned responsibilities by Mr. Letswalo that extended into the functions of departments, either in isolation or alongside the relevant senior managers. The committee observed that specialists were not only advising Mr. Letswalo, but were also exercising authority within operational divisions, thereby creating a parallel management structure. Mr. Burrell agreed with this characterization when it was put to him, stating that it was a parallel structure. He further testified that this arrangement created role confusion between the senior managers and the specialists, with uncertainty regarding reporting lines, decision-making authority, and the respective responsibility of line management and specialists. And we saw an example of that, members, yesterday when we dealt with the close protection and the fact that Mr. Msiza attended the board meeting to brief the board, notwithstanding that Mr. Lehomo was still the manager at that point in time. When probed whether these concerns had been raised with Mr. Letswalo or the RAF board, Mr. Burrell testified that to the best of his recollection, the board was aware of the existence of the specialists within the office of the CEO. And the committee notes that the former board members who appeared before the committee in Jan of this year were certainly aware of specialists, with Mr. Nyama referring to a cohort of specialists being brought in, and no former board member indicating any lack of knowledge of such specialists when the matter was referred to during questioning. The next section that we're moving to is on vacancies and acting appointments. So prior to the commencement of the inquiry, the committee had already identified that the organizational structure required closer scrutiny due to the fact that a number of critical executive and senior management positions were either vacant or occupied in an acting capacity. And the committee further notes that notwithstanding certain personnel changes reflected in the RAF 2024-2025 organizational structure, many of the vacancies and acting appointments identified in the previous reporting period remained. And below, that's just a diagram that indicates which of those posts are filled and if they're filled by whom, and which of the posts are vacant. And you'll see there quite a number of them that are vacant. And this comes directly out of the RAF annual report for 2023-2024. The committee is particularly concerned about vacancies and acting appointments in the following positions that are central to the RAF's operations, and that would be the Chief Claims Officer, the Head Claims Operation, the Head Legal Services, and the Head Enterprise Risk Management, the Head People Management, and the Head Revenue and Expenditure Management. The committee also noted that certain officials simultaneously performed substantive and acting functions. So these arrangements raise concerns regarding governance, operational continuity, accountability, and the RAF's ability to effectively discharge its statutory mandate. The documentary evidence submitted by the RAF reflected that several critical positions remain vacant, while others had been occupied in an acting capacity for extended periods. The evidence further showed that recruitment processes were at different stages, with some positions still awaiting the commencement of recruitment, others under recruitment, and certain positions placed on hold. That recruitment status is reflected in the table below, and that also comes directly from the RAF. The committee sought explanations from members of management, the former board and the interim board regarding the reasons for these prolonged vacancies and acting appointments, information on the recruitment processes followed, and the governance arrangements that they were implementing to ensure continuity of operations and effective oversight. And we first heard oral testimony from current and former members of the executive and senior management who had occupied acting positions, and these included Mr. Barral, Mr. Songilwa, Ms. Bonice Potgieter, Mr. Modiba, Ms. Manyashe, and Ms. Mampe Kumalo. Mr. Barral, who served in various senior human capital roles at the RAF between 2010 and March 2024, testified that while serving in his substantive position as general manager for organizational effectiveness, he also acted as chief human capital officer between April 2020 and June 2022. He further testified that he was subsequently appointed as the acting chief corporate support officer, a position that he occupied from June 2022 until his departure from the RAF in March 2024. Following his evidence regarding the extension of his own fixed-term contract, the committee sought clarity on the RAF's process for extending contracts at general manager level, and he testified that the responsible executive was required to submit a motivation to the CEO, who would then consider factors such as their performance and the critical and strategic nature of the role before consulting the board regarding any proposed extension. And Mr. Barral further confirmed that the extension of general manager fixed-term contracts was not arbitrary, but followed a structured process involving consideration by the CEO and oversight by the board. Ms. Manyashe testified that she joined the RAF in 2019, also on secondment from the Department of Transport, and was subsequently appointed as head in the Office of the CEO, a position which she described as providing executive management support to the CEO, including coordinating engagements with internal and external stakeholders. She also testified that she had previously worked with Mr. Litswalo at the Department of Transport before she joined the RAF. She testified that she was appointed as acting chief corporate support officer from 1 April 2024 until the end of August 2025, while remaining in her substantive position as head in the office of the CEO. According to Ms. Manyashe, as the acting chief corporate support officer, she was responsible for people management and corporate communication. The committee noted that Ms. Manyasha simultaneously occupied a senior management position, being head in the office of the CEO, as well as an executive position of acting chief corporate support officer. And the committee considered that the simultaneous performance of these roles raised questions regarding reporting lines, delegations of authority, and obviously the governance arrangements applicable to her holding both of those positions. The committee also noted from the RAF's organizational structure, which is contained in its annual reports, that Mr. Litswalo had assumed the functions of the Chief Claims Officer portfolio. So notwithstanding that he's CEO, he was acting as Chief Claims Officer. And the committee considered that this arrangement, together with the simultaneous performance of multiple roles by other officials, raised further questions regarding governance arrangements, executive accountability, oversight, and the allocation of responsibilities within the RAF. So definitely an unusual arrangement there. Mr. Songilwa testified that he joined the RAF on 1 October 2015 as the General Manager of Finance, and that he then acted as CFO from 19 June 2017 until 31 August 2017, and then later on again from 24 August 2018 until 2 June 2020. And he said that in his capacity as acting CFO, he regularly reported to the board through the CEO on the RAF's financial position and its status regarding outstanding claims liabilities. Mr. Songilwa further testified that he ceased acting as CFO on 2 June 2020 when Ms. Mabusela, who was the senior finance specialist at the time, was appointed to act in that post. Ms. Potgieter testified that she joined the RAF in 2010 and while serving as Senior Manager Financial Accounting, was requested to act as CFO on 27 May 2021, following that resignation of Ms. Mabusela, which, as I indicated, was a sudden resignation. The committee noted that this created an odd situation in which Ms. Potgieter was made acting CFO and effectively then moved a position above her manager, Mr. Songilwa, who then reported to her. She, however, indicated that in her view, it was not unusual and there are other senior managers who have acted in executive management posts. She further testified that a recruitment process was subsequently undertaken in which she participated, following which she was appointed as the permanent CFO then in that role with effect from 1 March 2022. As members know, she has subsequently been suspended. The committee also sought clarity regarding the prolonged acting appointment in the CIO position. That's the Chief Information Officer. And Mr. Modiba testified that he occupied the acting CIO position for approximately 2.5 years until he was placed on precautionary suspension in June of last year. The committee also examined the prolonged vacancy in the head legal services position, given the importance of legal services as a function relative to the RAF's core mandate, and also in light of the fact that there was a spike in litigation and default judgments in recent years. And Ms. Kumalo testified that Ms. Paladi Mogai had previously acted in the position and had been remunerated during her acting appointment, but later requested not to continue acting. She then testified that she thereafter assumed responsibility for the functions of the vacant post, with the senior advocates reporting directly to her. And she explained that she did not receive an acting appointment letter or acting allowance because the position in any event fell within her executive portfolio and would have been below her current level of employment. The committee further noted that during previous engagements with the RAF, prior to us starting the inquiry, Ms. Kumalo had informed the committee that she did not hold a legal qualification, and the committee considered that this, together with the prolonged vacancy in that position and the assumption of the functions of that position by the Chief Governance Officer, raised further questions regarding the governance arrangements applicable to the legal services function. By assuming the functions of the vacant post, it must follow that Ms. Kumalo would be required to perform operational and not merely management oversight tasks. So notwithstanding that legal services had always fallen under her control, the fact that she now acts in that post, it naturally follows that she would have to do certain operational tasks. that one would expect a person to be legally qualified to do. The committee also probed the process followed in appointing individuals in an acting capacity, and Ms. Khumalo testified that acting appointments were not advertised. Instead, managers themselves would identify suitable internal employees to act based on their skills and capabilities. And once identified, an internal memo would be prepared, and HR was informed to process the acting appointment and the applicable acting allowance. And this was corroborated by Mr. Modiba as well. The committee thereafter heard evidence from members of the former board, Dr. Mabuya, Ms. Msibi, Ms. Francois, and Mr. Nyama, regarding the reasons for these prolonged vacancies and the continued reliance on the acting appointments. And they sought to establish the extent of the board's oversight of recruitment processes, the filling of critical vacancies, and the continued use of acting appointments. And this would be specifically in the executive and senior management structure. Dr. Mabuya testified that the board assumed office at a time when the RAF was facing several challenges. And Mr. Nyama similarly testified that when the board assumed office, the RAF's principal organizational risks were assessed as either high or severe. Ms. Francois testified that the RAF had experienced difficulties filling certain executive positions. By way of example, she testified that the chief claims officer position, which Mr. Swallow had acted in for 3 years, had been advertised on more than one occasion, but the recruitment process was unsuccessful because they either failed to identify suitable candidates or candidates declined offers of employment. The committee questioned the former board regarding the prolonged vacancy in the Chief Corporate Support Officer post. And Dr. Mabuya testified that the recruitment process for the executive responsible for human resources had been expedited through the Remuneration Committee, or REMCO. And she testified that candidates had been interviewed and shortlisted, but that the process somewhere, somehow did not materialize to conclusion. She further testified that the matter was escalated to the board after it became apparent that the board was not getting results from the REMCO process. So according to her, the board recommended changing the chairperson of REMCO because it was of the view that the recruitment process was not receiving the required attention. She also told the committee that the board regarded prolonged acting appointments as a matter of concern and that these issues were discussed continuously at REMCO. She agreed that if you're acting, the labor laws do not agree to that. If you can act for 3 or 6 months, we might as well promote you or go through a recruitment process and place you there, because acting for 5 years, you are almost demonstrating competence of what they are doing. In her testimony, she noted that prolonged acting appointments resulted in employees receiving acting allowances over extended periods when permanent appointments should have instead been considered. She advised the committee that the board had concerns regarding the HR function, sharing that one of the board's key vacancies was the absence of a human resources expert on the board, and that notwithstanding this vacancy, the board continued to interrogate HR and labour court matters through quarterly REMCO reports. According to her, the board did question executives on why these matters remain unresolved, and whenever the RAF and whether the RAF could recruit people better equipped to manage the function, because the existing HR managers were, in her view, definitely not up to scratch. The committee sought clarity on the extent of the board's involvement in acting appointments at executive level. In other words, did the board have to approve these acting appointments? And Mr. Nyama testified that substantive executive appointments were the responsibility of the board. However, the process for appointing executives in an acting capacity was different, and that he understood it to be within the ambit of the CEO. He noted that this could be a gap that required consideration, i.e. the fact that the board doesn't approve these acting positions. The committee notes that in the case of Ms. Mabusela, Dr. Mabuya testified that she did not know her and could not remember her. This notwithstanding the pivotal role that Ms. Mabusela played in the change of the accounting policy as the acting CFO. So in response to questions regarding the board's oversight, Ms. Francois testified that the board approved policies and major financial transactions based on representation, supporting documents, and assurances it received from management that they were complying with relevant laws and RAF policies. She stated that the board exercised oversight by questioning management. When questioned about some of the matters that the board seemed to be unaware of, such as the increase in the security costs, the Morar report, etc., Ms. Francois acknowledged that with hindsight, the board could have gone the extra mile to independently verify certain information, and by doing so, they might have uncovered some of the issues earlier. She explained that the responses received from management appeared credible at the time and that the board had no reason to believe that they were being misled. Ms. Msibi similarly testified that information had been hidden from the board and that in retrospect, the board would need to reflect on how it could have exercised oversight differently while avoiding interference in operational matters. The committee then heard evidence from members of the interim board regarding the steps taken to address the vacancies and the acting appointments. And Mr. Dianchi testified that following the appointment of the interim board, it had identified the extent of the vacancies and acting appointments within the RAF, and they had commenced with interventions to address them. According to him, from August and September 2025, recruitment processes commenced for senior executive posts, including the CEO, head of legal, the chief operations officer, and the chief claims officer. He also testified that by the end of November 2025, the board had recommended the appointment of a CEO and had submitted its recommendation to the minister for approval. The committee does note, however, that that post has not yet been filled. Mr. Danji further testified that after concluding the recruitment process for the CEO, the board decided not to finalize certain executive appointments immediately, because in their view, it would only make sense for the incoming CEO to participate in the appointment of executives, given that those executives would now report directly to that office. Mr. Brown, the interim chair, testified that acting appointments were ordinarily dealt with by executive management in order to provide flexibility between board meetings. Obviously, if you're going to require board approval, it means that you would have a gap between board meetings. He testified, however, that prolonged acting appointments became problematic, and he further testified that permanent executive appointments fell within the prerogative of the board, whereas acting appointments were dealt with by executive management. So merely confirming what the committee had already heard from other witnesses. The committee noted with concern that acting appointments had become prolonged rather than being used as temporary stopgap measures. And the committee emphasized the importance of the RAF reviewing its HR policies and recruitment processes to ensure that critical vacancies were filled timeously and that acting appointments remained an exception rather than the norm. I'm then going to move on, members, to suspensions and financial impact of disciplinary processes. The committee received, and as I indicated, continues to receive serious allegations relating to disciplinary proceedings, suspensions, and dismissals. In many cases, submitters allege that these proceedings were retaliatory in nature or they're unsubstantiated. And whilst the committee sought to understand the legal costs associated with what appears to be widespread labour instability, it must be noted that a consideration of the merits of labour matters is not within the realm of the inquiry. So notwithstanding same, to the extent that witnesses were able to draw links between their suspensions and or dismissals, and the refusal to carry out certain instructions, the committee has considered same in parts of the report. So, for example, where we deal with the accounting policy, we then do go into the circumstances that led to Mr. Sungilwa's removal by way of example. Several witnesses who appeared before the committee during the inquiry also testified that they had been subjected to prolonged suspensions, some dating as far back as 2020. And these suspensions are usually on full pay, while acting allowances are then also paid to employees who now have to act in those vacant roles, thereby significantly inflating the RAF salary bill. Moreover, evidence before the committee revealed that for internal disciplinary processes, the RAF enlists the services of external lawyers, which has resulted in exorbitant expenditure on these prolonged disciplinary matters. So in most entities, you'd find that these are things that are done internally, and it's only if a matter ends up in the labour courts that you would seek external legal counsel. To quantify the financial impact of these disciplinary processes, the committee subpoenaed the following documents from the RAF. a detailed list of employees who were suspended from 1 April 2020 until 30 June 2025 on full pay, a detailed list of the number of acting incumbents, and a list of all law firms that acted on behalf of the RAF in these labor matters, together with the total cost for each year. So the insights below are drawn from those documents which we subpoenaed. From 1 April 2020 to 30 June 2025, a total of 188 employees were suspended for various matters. And these employees fall within different job grading levels, ranging from task level 6, which is the lowest level admin role, to task level 20, which is a senior management and executive realm of persons. So, members, we know that the RAF has just over 3,000 employees. Obviously, we don't have exact figures per year of the number of employees at the RAF vis-a-vis the number that would have been suspended. But 188 employees is roughly 6% of the workforce. Of those suspended employees, 35 were still on suspension, with the oldest suspension dating back to August 2021. And the highest salary was 6.58 million per annum for an employee who was on task level 18, who was suspended in August 2021. And notwithstanding how far back the suspensions date, disciplinary hearings of 24 of those 35 employees were reportedly still in progress. So this is now years later. 8 matters were still under forensic investigation, so they hadn't even proceeded to hearing stage, and 2 matters were awaiting outcomes, and 1 matter was awaiting a sanction report. Then of the 188 employees, 136 have had the employment terminated. The oldest suspension under this category started in Feb 2020 for an employee on task level 18 with a total cost of 6.95 million. And concerningly, for some cases under this category, terminations were successfully contested at the CCMA and the Labour Court, but the RAF continued to challenge the matters and did not reinstate the employees. As such, certain former employees continue to litigate or make claims for reinstatement and payment. In other cases, we have been told by some of these employees that they simply don't have the funds to continue litigating. The suspensions of 17 employees out of the 188 were uplifted by the RAF, and the oldest suspension under this category of uplifted suspensions date back to November 2020. 2 employees in this category were on suspension for approximately 4 years and 8 months. The total employment cost for their suspension period was 8.51 million for the employee on task level 18 and 6.75 million for the employee on task level 15. For the 2 employees referenced above, the RAF embarked on an internal review of the outcomes of their respective matters, which found that the employees were not guilty. So this notwithstanding the many years that these persons were suspended. The employees approached the CCMA for unfair suspension and succeeded. However, the RAF went on to review that CCMA award, and the cases were escalated to the Labour Court, which also then ruled in favour of the employees, and only then were their suspensions uplifted. Against this backdrop of employees being placed on prolonged suspensions, a list containing 46 acting incumbents for operational and support roles was provided by the RAF, 38 of which are still acting until further notice, while the acting term of 8 employees had ended. And obviously these numbers may have changed slightly from the date on which we received the info. The total cost of the acting incumbents amounted to 5.57 million, of which 3.69 million related to operational roles and 1.88 million related to support roles. Of notable concern is that there are incumbents who have been acting in roles since August 2020. In relation to detailed information of all the law firms that acted on behalf of the RAF, costs were disaggregated in terms of disciplinary hearing, where external services were utilized, then the CCMA proceedings, and then Labour Court representation if it proceeded to that level. For each year, a list of the same 17 law firms is provided. So for 2020, costs were associated with only 3 law firms at a total cost of 2.23 million. Of this amount, disciplinary costs were 1.26 million, CCMA costs were 724,000, and labor costs 247,000. Then in 2021, that number goes up to 7 law firms with a total cost of 8.34 million. And of this amount, disciplinary costs total 1.2 million, CCMA costs 3.5, and labor court costs 3.5. And it's all captured in the pictorial below. For 2022, and we now start seeing things climbing significantly, labor costs are now associated with 9 of the 17 law firms at a total cost of 22.21 million. So 2020, I had said it's 2.23 million, and we're now at 22.21 million. And of this amount, the CCMA portion is 10.4 million, and the labor court costs 12.8. In 2023, labor costs associated now with 10 of the 17 law firms at a total cost of 42.36 million. So it really doubles from the year before. And of this amount, disciplinary costs totaled 9.7 million, CCMA 16.2, and labor costs 16.02, and labor court costs 16.6 million. For 2024, labor costs were associated with 7 of the 17 law firms. So we're seeing a little bit of a drop at a total cost of 24.5 million. And of this amount, disciplinary costs were 6.64 million, CCMA costs 11.18, and labor costs 6.69 million. For 2025, labor costs were associated with 10 of the 17 firms at a total cost of 21.61 million. And of this amount, disciplinary costs total 12.77 million, CCMA costs 4.27 million, and labor costs 4.5 million. The consolidated total cost paid to law firms for labor-related matters, therefore, for the period 2020 to 2025, totaled 121.26 million rand. To better understand these matters relating to these prolonged disciplinary processes and the associated financial costs, the committee engaged Mr. Barrell, who was the acting chief human capital officer at the height of the prolonged suspensions, as well as Mr. Letswalo, the former senior manager of human resources, not to be confused with the former CEO. And the committee first sought to verify the concerning allegation from witnesses who appeared before it and shared that disciplinary action taken against employees was not always initiated by a line manager, but rather on the instruction of executives. So an example of this relates to the 200 claim handlers across various RAF regional offices who were identified for suspension or dismissal, allegedly on the instruction of senior executives. According to Ms. Mtetwa, the former manager for originations, notwithstanding that there was a shortage of officials coupled with the termination of the panel of attorneys in 2020, claim handlers were disciplined in connection with default judgments and failing to make requests for payments within 180 days. And in her affidavit, she says that claim officers had raised the challenge that their departments were understaffed and each one of them had, on average, more than 2,000 claim files assigned for them to work on. And on top of that, they were expected to manage not just the files, but they also had to attend court sessions and consult with plaintiff attorneys in the office. And Mr. Barrell testified that under normal processes, a line manager would assess alleged misconduct and then involve HR to verify the type of misconduct. Following that, the identification of the offence, HR and the line manager would jointly prepare a charge, which would be signed off before a disciplinary hearing. Notwithstanding this, he confirmed that there have been cases where instructions came from executives or even from Mr. Letswalo himself to initiate disciplinary action. In such cases, HR would not derive matters independently, but would act on instructions from managers or executives. Mr. Litswalo also conceded that indeed there were instances where human resources initiated action despite objections from line managers. So a case in point would be Ms. Mtetwa. He testified that on the matter of the 200 claim handlers who were suspended, Menlyn branch was the most affected region, and general managers were advised that the directive came from Mr. Litswalo, being the former CEO. The committee heard that managers of most of these claim handlers were against the suspensions because it would remove the capacity that they needed to manage and process claims. Mr. Litswalo testified that NUMSA, which was a majority union at the time, tried to negotiate for an amicable solution to the matter with Mr. Litswalo. However, he merely stated that he does not negotiate discipline. When the committee probed the fairness of the process and whether it was common practice for suspensions to be preceded by investigations, Mr. Burrell testified that ideally investigations should precede suspensions. However, at the RAF, processes take long. The committee then traversed the matter of prolonged suspensions, seeking to understand the rationale and the reasons behind having employees sit at home on full pay in most instances, while incumbents were paid to act in their roles for unspecified periods. And Mr. Burrell acknowledged that disciplinary matters take an extraordinary length of time to conclude. And according to his testimony, the prolonged suspensions are influenced by the outsourcing of investigations. He explained that panels of investigators from internal audit, the legal department, and compliance conduct the investigations, which take time. And he further expanded that external chairpersons are also used depending on their availability. Employees are also allowed legal representation, and all of these put together then extends the timelines. When probed on whether the HR policy provides in the guidance in respect of the length of suspensions, he testified that the period should not be more than 6 months. He, however, elaborated that the period may, in exceptional circumstances, be extended by the senior manager for HR, the chief human capital officer, and the responsible executive. The committee had registered its concerns on not only the unfairness of these unnecessarily prolonged suspensions, but also on the resultant financial impact that they carry, as evidenced by the documents before the committee. The next matter that was canvassed was the use of external lawyers for these internal disciplinary matters, the CCMA matters, and the Labour Court matters. And the committee sought to ascertain the extent of this practice and the rationale thereof, given that it's a costly exercise, not only for the RAF, but for the employees as well. One would appreciate that where an entity is using attorneys to conduct these sorts of processes, you then put the employees that is being subjected to the process in a weaker position, almost forcing them then to have legal representation, even if that wouldn't have been the original intention. So in most entities, one would find, in fact, that individuals are not allowed in these initial proceedings to use attorneys, but you may be represented by a union member or a fellow employee. In the RAF, it appears to be different. Mr. Burrell testified that the rationale advanced by the former CEO, Mr. Litswalo, was that the RAF cannot adjudicate itself as it was conflicted. Therefore, a legal panel responsible for disciplinary matters was sourced through the RAF's legal department. And he elaborated that there's a panel responsible for initiating disciplinary matters, then another panel for chairing, then a panel for CCMA matters and the Labour Court disputes. And Mr. Burrell confirmed that the use of external lawyers significantly inflated the costs associated with suspensions. Mr. Litswalo's testimony corroborated Mr. Burrell's evidence, and he conceded that a lot of money could have been used elsewhere went into these disciplinary matters. And he testified that he once had a discussion with Mr. Burrell regarding getting assistance from sister organizations within the transport sector to get initiators and chairpersons in an effort to avert the exorbitant costs that come with appointing external lawyers in DC matters. However, this did not materialize given that the practice of using external lawyers still exists at the RAF. So this also is not something out of the ordinary where an entity may use another entity's staff to assist it. You sometimes see it even with the legislatures. You may have a provincial legislature that needs to conduct a disciplinary matter, and instead of using somebody within the legislature, you ask a fellow legislature if they can avail a person, and that way you significantly cut your costs, because you obviously don't pay the person a fee. You would merely have to pay for any transport and other associated costs if there are such costs. The committee sought to further ascertain the rationale behind this trend of the RAF appealing outcomes that rule in favour of employees on labour matters, and then the refusal to execute reinstatements even after court orders. And Mr. Barral testified that the decision to appeal falls within the ambit of the legal department, so it's not an HR function. And the legal department would make that decision in consultation with the CEO. Moreover, he testified that there was a lack of appetite to reinstate employees who are deemed to be anti-transformational, and that instructions not to reinstate would come from executives or Mr. Letswalo himself. Mr. Muteng Letswalo confirmed this. He testified that the former CEO took keen interest in labour matters, particularly dispute resolution. And he says that they were told throughout that they don't settle matters, they need to defend matters. And the paragraph below provides an example of that. The former RAF board was questioned on the matter of defying court orders in respect of reinstatements and the long acting periods. And Dr. Malela said that the fact that court decisions were defied, that particular matter never emerged in terms of those quarterly reports. She would have been referring to the REMCO reports here. And what they were aware of was that ER managers were definitely not up to scratch. And hence, they're sitting with all of these hearings where they're wasting time and people are getting acting allowances. She did indicate that it was quantified at some stage, and she herself now questioned if somebody can act for 5 years, why didn't you promote that person? She indicated that in her view, they were violating labour laws. The committee registered its disapproval of the RAF using public funds to fight unnecessary legal battles instead of accepting the outcomes of these DC processes and court orders. And the committee also highlighted the financial and emotional toll these unjust labour processes have on employees and former employees. And in response to that, Mr. Barral indicated that if you have the financial muscle, especially against an employee who does not have the financial resources, the playing field is in favour of the organisation that has the financial capability to see the matter through. So he concurred that the organisation may have used or did use public funds to fight some of these particular matters, knowing that the expense and the cost involved in the litigation is a costly matter itself. So you really weigh down your opponent from a financial position, notwithstanding that your case may be weak effectively. When probed on what the senior managers and executives within the HR department did to address these procedural injustices relating to suspensions and the litigation, Mr. Barral testified that he would personally submit recommendations to the former CEO or the executive stating that the outcome of a particular matter, such as reintegrating the employee back into the RAF, but his request would be ignored. Moreover, he testified that as the acting head for human capital, he absorbed a lot of the pressure coming from the executive level, and that there was a culture of fear, especially at senior management level, around Mr. Letswalo. This testimony was echoed by the other Mr. Letswalo as well, who testified that I think I've explained that we were getting instructions, and there were times when you would be told that if you don't do it, then you are going. That is the type of environment that we operated in. You either do what you are told to do, if not, then your job is also on the line. The testimony of Dr. Mabuya Malela supports the contention that the working environment was toxic. And she referenced that the wellness reports were showing that the levels of mental issues were not manageable. And they, in fact, even questioned whether they still had the same service provider or had they changed service providers to try to understand what was happening. We then moved on to security vetting of executive management. And again, this is one of the matters that the committee dealt with even prior to the start of the inquiry, because the committee had identified inconsistencies in information provided by the RAF concerning the security vetting status of senior executives. So during previous engagements in October 2024 and then late in March 2025, Mr. Litswalo, the former CEO, had indicated that he had been vetted by the SSA. However, subsequent written submissions by the RAF reflected that he was not vetted. So these inconsistencies raised concerns regarding the accuracy of information provided to the committee and the RAF's processes for managing the security vetting of senior executives. And the committee sought then to establish the vetting status of these executives, the process that was followed by the RAF in relation to security vetting and the reason for the discrepancies in the information provided. So in response to the committee's requests, the following table was submitted by the RAF, and you'll see that it lists the names of various executives together with their positions, the level of clearance that they required, whether what the status was of the security clearance, and the dates on which it would have been submitted to the SSA for further processing. And you'd see that in respect of the majority there, these applications for clearance have been submitted, but in the case of Mr. Litswalo, who requires top secret security clearance, it was not submitted. The remaining executives, as I've said, are in different stages of the vetting. And the committee then heard evidence from Mr. Mshlanga, the former manager of physical security at the RAF, regarding a request from the State Security Agency to the RAF requiring it to produce information on the security vetting status of its executives. And Mr. Mshlanga testified that he was provided with a draft response to that letter that had been prepared by a subordinate in his unit. And in terms of that draft response, it had indicated that Mr. Litswalo does possess top secret security clearance, but he declined to sign that response because he himself had not personally seen any documentary proof that Mr. Litswalo held a top secret security clearance, despite an alleged email from his office indicating that he did. He then testified that at the time, the RAF had already initiated a security vetting process for Mr. Litswalo because security clearances were not automatically transferable between institutions. And he explained that because it was a risk-based assessment, it would have required the authorization of the SSA. And he testified that he only became aware during subsequent parliamentary proceedings that Mr. Litswalo did not hold a top secret security clearance. So the way it works in the public sector is that notwithstanding that you may have a valid clearance that is still valid for another year or 2 years, whatever the case may be, if you leave your current place of employment for another organ of state, that won't be automatically transferable unless you get permission from the SSA. And that follows because obviously the type of risks and the type of information that each entity deals with is vastly different. The draft letter was eventually then signed by the security specialist, Mr. Stephens Msiza, on 8 December 2021. And according to Mr. Mshlanga, following questions by Scopa on the vetting status of Mr. Litswalo, the official who prepared the letter was subjected to a disciplinary process by Mr. Msiza on the basis that she misled him. So whilst we had one official that refused to sign the letter because he didn't see documentary evidence, we had Mr. Msiza that did sign the letter, notwithstanding that he didn't see the documentary evidence, and then proceeded to subject this person to a disciplinary process that had prepared the letter. The committee thereafter heard evidence from Mr. Msiza, who confirmed that Mr. Litswalo had not been vetted. And he also said that executives were vetted by the SSA rather than through the RAF's internal vetting process. In response to questions from the committee regarding information received from the SSA indicating that it had not received a vetting form in respect of Mr. Litswalo, Mr. Msiza confirmed that this information was accurate. And he said that initially Mr. Litswalo had indicated that he had submitted the required documentation while employed at the Department of Transport. And he further testified that when another SSA vetting form was issued to Mr. Litswalo, in other words, when he began at the RAF, he indicated that he would not complete it again because the Department of Transport should finalize the process. The committee also questioned Ms. Manyasha regarding earlier information presented to the committee concerning Mr. Litswalo's vetting status, and she testified that the information previously presented to the committee reflected that the SSA was in the process of finalizing the vetting. She further explained that although Mr. Litswalo had been interviewed, the interview had not been conducted for his own security vetting, but rather in respect of other officials. When asked directly by the committee whether Mr. Litswalo had been vetted, she replied that he had not been vetted. So typically, when a person is being vetted, if I, as an official, Fatima Ibrahim, is being vetted, the SSA then may interview some of my colleagues to confirm certain things or to ask certain questions. But if, for example, the chairperson is interviewed in respect of my own application for security clearance, that doesn't mean that the chairperson is being vetted, merely that he's being requested to provide information on myself. And it appears that the information given to the committee that he had been interviewed was given in such a way as to lead the committee to believe that he was being interviewed by the SSA in respect of himself rather than in respect of other officials, as Ms. Manyasha then explained to us. The committee then also heard evidence from members of the former board regarding their oversight of the vetting process in relation to executives, and Ms. Francois testified that the board relied on reports and written assurances provided to it by executive management, together with information that they would have received through internal audit and AXA. She stated that management had represented that the required documentation had been submitted to the SSA, and they attributed delays in the vetting process to a backlog at the agency. She further testified that after the board became aware of concerns regarding Mr. Litswalo's vetting status, that they had written to the SSA requesting confirmation of the vetting status in respect of Mr. Litswalo as well as other executives. She stated that it was at that stage that the board became aware that Mr. Litswalo had not submitted the minimum documentation required for vetting. The committee is in possession of the aforementioned letter dated 25 June 2025, signed by Ms. Francois in her capacity as chairperson of the board, requesting the confirmation of the security vetting status. In the correspondence, the RAF referred to clause 22.1.4.7 of Mr. Litswalo's employment contract, which required him to obtain top secret security clearance. The RAF requested confirmation as to whether Mr. Litswalo had applied for the required security clearance, the outcome of any vetting process, and where applicable, the reasons for any refusal or outstanding status. The board also requested confirmation of the submission status of the vetting applications of the remaining execs. Concerning the correspondence from the SSA dated 10 July 2025, in response to the board, confirmed that no vetting form had been received from Mr. Litswalo, and they confirmed, however, that the remaining executives were at various stages of the vetting process, including investigation, polygraph examination, and evaluation. Mr. Janshis testified that the interim board had introduced revised arrangements for the SSA to improve the security vetting process and was actively monitoring outstanding applications. He further testified that the interim board had incorporated security vetting considerations into its recruitment processes for senior appointments. Chairperson, this now brings us to the findings and observations on this section. Firstly, the recruitment of several specialists was influenced by Mr. Litswalo's pre-existing preference for specific individuals, creating the appearance that the recruitment process was conducted to legitimize predetermined appointments rather than to facilitate a fair and competitive recruitment process. The committee finds that on a balance of probabilities, it is extremely unlikely that these pre-existing relationships, which varied in form, there were some specialists who described themselves as being friends with Mr. Litswalo and others saying merely they had a professional relationship, that it would be unlikely that these relationships were coincidental. This is supported by evidence that Mr. Litswalo would have preferred to conduct a headhunting process but was restrained by policy. Although these specialist positions were approved as fixed-term appointments to support the RAF's organizational transformation, specialists were subsequently parachuted to occupy or act in senior management roles after the incumbents occupying those positions were either removed or suspended. The committee therefore finds that the creation of these positions served as a gateway for Mr. Letswalo to position people according to his preference. The key roles which these specialists subsequently occupied were central to major decisions taken by the RAF, such as the change in accounting policy, which resulted in the significant understatement of the claims liability by more than 300 billion, and a failed debt restructuring plan, which sought inter alia to secure a credit facility for the RAF and to satisfy judgment debts. The RAF's executive and senior management structure was characterized by prolonged vacancies in several critical positions. At executive level, key positions included Chief Claims Officer, Chief Corporate Support Officer, Chief Investment Officer, and Head Legal Services remained vacant or were occupied in an acting capacity for extended periods. At senior management level, several critical positions, including Head Claims Operation, Head People's Management, and Head Enterprise Risk Management, remained vacant in some instances for more than 2 years. The committee found that these prolonged vacancies undermined the organizational stability, leadership continuity, and the effective execution of the RAF statutory mandate. This finding is echoed by a recent briefing to Parliament by the Department of Public Service and Administration, which emphasized that acting appointments affect continuity and institutional memory, create service delays due to delays in decision making, and in the implementation of institutional priorities. In addition, acting posts adversely impact institutional efficiency, as officials in such posts must still perform their substantive job functions. Recruitment processes for several executive positions were repeatedly unsuccessful, delayed, suspended, or not concluded, resulting in prolonged vacancies and continued reliance on acting appointments. The committee finds that these recurring failures reflect weaknesses in succession planning, recruitment processes, and the overall effectiveness of the HR function. Whilst it is generally accepted that acting appointments do not require a formal recruitment process, the committee finds that the lack of board approval and oversight over acting appointments resulted in prolonged appointments. The questionable appointment of a middle manager, being Ms. Potgieter, as an acting CFO, even where there was a competent senior manager to occupy the role, and a situation where the board did not even seem familiar with all persons who may have acted in executive positions, as in the case of Ms. Mabusela. This lack of an adequate governance framework created a significant oversight gap and effectively devolved board control to Mr. Letswalo. The former board failed to exercise effective oversight over the management of executive vacancies and prolonged acting appointments. Although the board acknowledged the risks associated with these arrangements, it did not ensure that critical vacancies were filled within a reasonable period or that acting appointments remained temporary in nature. The evidence further demonstrated that the board relied predominantly on assurances from executive management regarding recruitment processes and governance matters, and did not independently verify whether appropriate action had been taken. Consequently, prolonged vacancies and acting appointments continued for years without effective board intervention. Further, the RAF has normalized prolonged suspension by circumventing prescribed human resource prescripts, which provide that suspensions should last a maximum of 6 months, whereas some suspensions lasted over 4 years without being finalized. This practice is not only abusive and unjust to employees, but constitutes fruitless and wasteful expenditure. The knock-on effect of these unduly prolonged suspensions has added a significant financial burden to the RAF due to the continued payment of full salaries in most instances to suspended employees, while simultaneously paying acting allowances to incumbents who fill the vacuum created by the suspensions. These prolonged disciplinary matters have severely diminished the operational capacity of the RAF, which is already under extreme capacity constraints. The use of external lawyers and chairpersons to preside over internal disciplinary matters instead of internal human resources staff is extremely costly, with evidence showing that the RAF has spent approximately 121 million strictly on legal costs between 2020 and 2025, money that could have been channeled to other critical areas within the organization. Moreover, the RAF has become a law unto itself by refusing to abide by court-ordered reinstatement of employees, who have successfully challenged the undue suspensions. This further calls into question what the motive of these suspensions are and whether they are in fact without merit. Of notable concern is testimony that disciplinary matters were not always conducted in terms of prescripts, and in the case of claim handlers, appeared not to take into consideration the impact of management decisions on the ability of staff to perform their duties. It thus appears that staff may have indeed become scapegoats for bad decision making at the executive level. Mr. Letswalo created a culture of fear within the RAF to a point that senior management and executives acted on instructions which were not in line with standard operating procedures and without due regard for the implications of those instructions. This culture of fear has had a negative impact on staff morale across the organization. The mental wellness issues, which were described as unmanageable by Dr. Mabuya, would undoubtedly have resulted in additional expenditure in the form of sick leave applications and also impacted on production levels. The personal cost to those affected individuals, however, cannot be quantified. The committee received patently false information regarding the security vetting status of Mr. Letswalo. During previous engagements, Mr. Letswalo indicated that he had been vetted. However, subsequent documentary evidence submitted by the RAF, correspondence from the SSA, and oral evidence of witnesses established that he had not submitted the minimum documentation required for security vetting and did not hold the required top security clearance as contemplated in his contract of employment. The committee notes that it is a criminal offence to willfully provide false information or mislead Parliament. The committee further finds that Mr. Msiza ought to reasonably have known at the time of signing the letter to the SSA that Mr. Letswalo had not obtained his security clearance and that reliance could not be placed on him having previously submitted the form in respect of his previous employment. The committee finds further that the RAF did not have effective governance arrangements to monitor, verify, and report on the security vetting of its executive management. The former board relied predominantly on representations and assurances provided by executive management, together with internal audit and other assurance mechanisms, without independently verifying the status of executives' vetting with the SSA. The board only sought direct confirmation from the SSA after concerns regarding Mr. Letswalo's vetting status had already been raised, by which stage it became apparent that the information previously provided to the board was incorrect. The RAF failed to ensure the timely security vetting of its executive management. At the conclusion of the inquiry, the security vetting of several executives remained incomplete, with officials at various stages of the vetting process, including submission, investigation, polygraph, examination, and evaluation. The committee is concerned that an organ of state responsible for administering approximately 50 billion in public funds continues to be managed by executive officials whose security vetting has not been finalized, exposing the RAF to unnecessary governance and security risks. Members, there's then one further finding that we added that will not be on the document that was circulated to you yesterday, but is on the version that's in front of you that's now being displayed on the screen. And it reads, various persons who testified before the committee provided compelling evidence that their suspension and or dismissal was based on unjustifiable and unsustainable allegations. Whilst the committee cannot delve into the merits of individual matters, it is of the view that there is certainly a nexus between the suspensions and or dismissal of a number of individuals and their actions in relation to challenging matters or raising legitimate concerns. The committee is firmly of the view that the raising of questions and concerns is a vital tool for accountability, transparency, and good governance. Robust engagement on decisions and a willingness to listen to and understand different viewpoints is critical, ensuring that risks are mitigated and decisions can rationally and legally be defended. Thank you, Chairperson. That brings me to the end on this marathon section on the HR matters.
Sure, Mr. Ibrahim, thank you very much. Honorable Kupeka, I think that's an old hand, so if you can take it if you can take it down so that we can start afresh with new hands, that would be helpful. I'm
Apologies,
just
Chair.
all right. No, thank you very much. I'm just going to maybe just make some initial inputs, and then we can have a discussion. And that is, I think we've taken a decision wisely, in my view, not to review labor matters pertaining to individuals specifically, because A, there are too many, B, we are not competent to do so in any event. But I just want to go back on our journey with HR related matters at the Road Accident Fund. A concern that, from my perspective, continues to this day. I don't think things have gotten better. And I'm going to just refer to a few pieces of information that we've looked at over time. One of the issues we did look at as a committee was the number of vacancies on the executive committee, if you recall, when we saw the annual report of 2023-2024, and we looked at the organogram, the number of vacancies on that structure was alarming. There was no chief claims officer, if you recall. There were several other vacancies that were there. And when you don't have vacancies and people act in different roles, you might have conflicts of interest in that roles that should challenge one another with regards to risk identification and mitigation are now collapsed under one person, as an example. That raises governance matters that may then have an impact on how much money the organization spends overall. So there were those vacancies. Now, in particular with the vacancies, you will recall that when we were at I think it's 546, the room downstairs, and the board had come to us, the situation with acting executives had become so serious at some point that the board members could not remember Ms. Mabusela at all, and were to try and remind them. Now, it's undesirable. I think if any organization appeared before Parliament and board members could not recall a whole chief financial officer, we would correctly be alarmed. And that points to the quality of oversight, but also systemic issues where there are all of these failures. So on the one hand, if roles are acting executive roles, even though a CFO role is critical, the board does not get involved. That was one example. Then yesterday we dealt with the delegations of authority, where there is no limit to who can keep on delegating and so on. So these point to weaknesses in the system that just cannot be allowed to persist. That is the one basket of issues. There is a second basket of issues which pertained to the number of people that were dismissed over time. One of the submissions made to us earlier on before the inquiry, which partly informed the reason we had an inquiry. If you recall, in the legal department, there were about 28 senior legal personnel that were removed from suspended, they resigned, they left. Some of them were too scared to testify, and so on. The Road Accident Fund is a highly litigious environment. You can't divorce that from the escalating legal costs that arise out of the Road Accident Fund, where the lawyers don't have a mandate and there's just no one to represent the Road Accident Fund at all in court. So we have to try and look at things systematically, because they do have an impact on the performance of the organization and its ability to deliver on its mandate. So there is a second basket of issues where things we're dealing with in the HR space have an impact, not just on expenditure, but on operational effectiveness, and therefore how much money the organization ends up spending. That was the second basket. The third basket was what was just a strange phenomenon to me, where an organization right at the beginning chooses to use lawyers throughout. The initiator is the attorney, the presiding officer is the attorney, etc. And then all the way through to CCMA and labor court and so on, you use attorneys throughout. Now, employers tend to use managers and supervisors and other internal personnel at the first instance, and then only start spending money when matters go to labor court. In many instances, even at the CCMA, the HR people represent the organization at the CCMA and so on. So there were some practices around the management of IR, which I think is important. The fourth basket has got to do with employee wellness issues. in particular arising out of what appeared to be a really difficult operating and toxic management culture. Why do I say that? You will recall the case of Ms. Flop from KZN, who won at every stage and was denied the right to return to work each time. And even when there was an enforcement order for her to come back to work, she was not given any work to do. As we sit here, I don't know what his situation is. There was Ms. Mtetwa, etc., etc. So Ms. Mtetwa was being charged on the basis of the Sunshine Report. The Sunshine Report found nothing wrong. But we had this strange situation where the only information available to the committee is that there had not been collusion between staff and Sunshine Hospital, but you've got a whole slew of staff who are being charged on the basis of a report that simply does not exist. And monies are being expended on lawyers for the purposes of doing so. And the last one I need to make is that we had incidences where we had grown men crying in front of our committee because of the environment that we had there. Now, we can't deal with those issues on an individual basis, but that is one of the things that caused me to go to the annual report and look at the wellness report. And the wellness report is devastating. I just want to say that to the extent that we may have different views on this, this democracy was brought on significantly by the struggles of workers in South Africa. The Labor Relations Act, the Basic Conditions of Employment Act, and all of these laws are the sweat and tears of workers who worked very hard to make sure that we've got a labor regime that respects the dignity of workers. The only thing I'm going to say is that even though we're dealing with matters that have got to do with expenditure, I think we have a moral and constitutional obligation to also ask the Road Accident Fund Board to make sure that the labor relations environment at the Road Accident Fund is fair, that workers' rights are respected, that workers are respected as individuals and as people, and that when there is a cause for disciplinary action, and it must be taken whenever it is necessary, that it is fair, it is just, and it is quick. And at the end of the day, the employee, as difficult as it may be, they might accept the outcome to say that, look, fair is fair. I had a fair process. I represented myself. I think the entire process was fair. So what I'm trying to say is that there are some things to navigate for all of us here, because we can't review cases, but there was a whole range of issues, I guess, which may be intangible to deal with on an individual basis. Let me put it like that. So thanks, Ms. Ibrahim. I'm hoping that you've had some time to drink some water as well, or tea. I can see two hands at the moment. So I'm going to take Alan, I nearly said Comrade Alan Beasley, Honorable Alan Beasley's hand. And then Honorable Patrick. How are you, comrade? How are you, comrade?
I don't mind being called anything except me lord, so that's fine. So, but for the record, I have run Comrades Marathon, so
then you are a comrade then.
It is fine. So yeah, thank you, Chair. So Chair, I just want to start off. Obviously, Mr. Latsalo has refused it would have just been so great if he did come to this committee, but what is the latest on the criminal charges? If you can just update us on that. And I think the way that you summarized the points at the end, I think we're brilliant, but I don't think they found, I don't know if the right word is reflection, expression in these recommendations, because what struck me in this hearing is the human cost on people. It is traumatic to see grown men cry. People who are doing their best, and I don't think that has found expression in this thing. That is, people that were dismissed or suspended. The human toil on them has been massive, and I don't think that has found expression in that. And I would like to do it because it did have a huge impact on me. I visited Meslopian Hospital, and the impact that it's had on staff is just massive. And I don't think it's found expression in this, that the human toil on staff And it's fine, we can talk about staff going forward, but we also need to reflect on the staff that have been totally traumatized through suspension and unfair dismissal. And then the other thing that I also don't find expression here is that that obviously 120 million used to fight legal fees, but essentially they were bullying. The RAF were bullying staff into submission. And I don't think that it's found expression here too, because when a person's dismissed, it's something that was suspended, it's something that they have to carry on their CV. They have to reflect it. And RAF has used state money to bully staff. And I don't think that it's found expression. And I think that needs to be noted, because as members of parliament, bullying is one of the worst forms of character, and using state money to bully people into submission where they actually cry and they end up in psychiatric hospitals. And I just don't think that that's found expression there, that it's an unfair battle. And then the last point is, and I don't know if it came up in the committee or if somebody mentioned it to me. I think Mr. Yankees actually mentioned it to me, that they're going to review all past suspensions and dismissals. And that hasn't found expression in this report either, because I think as a committee, we need to say that, because when there has been wrongs doing, using state resources to commit these wrongs, they need to be recommended. So I think one of our findings should be that past suspensions and dismissals, and obviously we're not looking at it on an individual basis, needs to be reviewed, because we need to correct the wrongs of the past. Thank you, Chair.
Thanks, Honorable Beasley. That's very well noted. And just to say that we're not at recommendations yet. We're going to pull everything together and then make an integrated set of recommendations. But we'll take these comments into account, definitely. Honorable Atkinson.
Thanks very much, Chair. Chair, I think when one goes back and looks at the very basis of natural justice and law, it's to protect people from arbitrary actions. And really what we see here is a case of completely arbitrary actions by a person who effectively saw himself as above the law. Basically, reading between the lines, what Mr. Letswalo did was he just got rid of anyone who stood in the way of him conducting his unlawful practices, such as a RAF1 form, such as taking on the Auditor General about the accounting policies, or anything else that he did that was actually contrary to the law. And in fact, all the stuff about running HR practices via lawyers and everything was all completely unnecessary. And basically anyone that disagreed with him, as was said in this presentation, was basically told that they could walk. I mean, it's a complete disgrace that this was actually allowed to go on for as long as it did. And I know there's certain members of the committee that might wish to stand for Mr. Letswalo, but at the end of the day, it's one of the clearest cases possible of someone who is in a position of authority and strength, who basically took on ordinary people and actually tried to destroy their lives. I mean, it's inexcusable. It really is. So what I wanted to say was, I do know that there is, in fact, Honourable Beasley asked about the legal action against Mr. Letswalo for not appearing before the committee. But there's also a further legal action by the fact that he did lie to Parliament around the vetting, the security vetting. And this is no small thing, because the reality is, without a security vetting, he actually shouldn't have been in that job anyway, because the CEO of the Road Accident Fund required, I'm not sure if it's a top secret clearance, but it certainly required an extensive security clearance. And quite obviously, Mr. Letswalo was without that at all. So it actually even put into question whether he should have been in that position at all or not. So the fact that he lied to Parliament about the validity of his own appointment, because he was lacking the one critical factor of it, being the security clearance, is an extremely serious matter, and should be subject of a separate charge against him for lying to Parliament, as was said earlier. There were a number of other things that he skirted the levels of truth, and we know that in that discussion we had with him about chief investment officers and treasurers and everything, he was purposefully obfuscating the situation there. because he didn't want to try and explain why he had appointed a chief investment officer when there should be no long-term investment of money. But the reality of this is, again, an outstanding piece of work done by Ms. Ibrahim and her team. And I would just say that I really, really do hope that such an egregious case of arbitrary actions against ordinary people, which have completely destroyed people's lives, that he doesn't walk away scot-free from this, that he actually feels the might of the law on his back for the laws that he's broken and the contempt that he's actually shown towards Parliament, and the fact that he felt blameless enough to lie to us, basically, and also that he didn't deign to appear before us either. So I do hope that the recommendations take the strongest possible action against Mr. Lotswalo for his failings and for his disgraceful actions. Thank you.
Thanks, Honorable Atkinson, and its comments are noted. So let me, together with Mrs. Ibrahim, deal with the issue of the non-appearance and the laying of criminal charges. So, Ms. Ibrahim, I'll just provide the background, and then you can provide the specifics. So you will recall that the Speaker had said that it's not necessary for us to get the concurrence, in which case the Secretary to Parliament had to initiate. So the Secretary to Parliament then asked the legal department to lead in that process. There was a meeting. I was planning to address this at the end of the proceedings today. There was a meeting held in Parliament between the SAPS and the Secretariat, myself, and Ms. Ibrahim herself, to explain the circumstances, the issues, the legislative, the statutory issues, as well as the facts to the SAPS, so that we can then guidance on how to move forward, because as we had said, this had not happened before. So, Ms. Ibrahim, I don't know if you can brief the committee on that so that we can deal with it now.
Thank you, Chairperson. So, Chairperson, we were requested to provide an affidavit setting out the nature of Parliament's complaint, what the allegation is in terms of what law has been contravened, to ensure that we supply all supporting documentation and so on. And we are in the process of doing that. And our understanding is that after that affidavit has been compiled, and it's likely that I'll be the person that does that affidavit on behalf of the committee, simply because SAPS was of the view that I have been involved in the matter and would have the necessary background, especially on the legal issues, to be able to draft that affidavit. So once that's done, they will then confer with the National Director for Public Prosecutions, and they will take the matter from there. So as soon as that's done and we get any feedback, we'll be able to give the committee feedback. But we obviously have no control over the length of time of that process, Chair.
Yeah, just to be clear, didn't they say the provincial director? I thought they said the provincial director rather than the national.
Apologies, Chair. Provincial.
Yeah, just the provincial director. So, honorable members, that's where the process is. To give a sense, the supporting documents aren't complicated, because when we had to ask for concurrence from the Speaker, we had to compile a very detailed list of documents and index them for the Speaker's consideration of why we wanted to. So every piece of correspondence between ourselves and Mr. Lotswalo's attorneys and Mr. Lotswalo himself, etc., and index it carefully. So the statement accompanies that bundle of documents. It is then up to the SAPS and the NPA to then take the matter forward accordingly. I just wish to emphasize that the prosecutorial decisions rest exclusively with the NPA, and they would therefore need to test the strength of the case and then make a decision, an independent decision accordingly. They would obviously inform the complainant, that being Parliament, of what their decision is, but the investigation is SAPS, as well as the decision to prosecute or not rests with the NPA. Thanks very much, Ms. Ibrahim. Honorable Kubeka, and then Honorable Skosana.
Thank you, Chair. No, Chair, just one thing. Our investigation into this whole situation with these people who are employed and all of that, and our report says that Mr. Letsoalo looked at hiring specialists, or the RAF looked at hiring specialists. I think my question, Chair, and what I would like us to possibly highlight is, what is a specialist, Chair? Is it someone who has what do you call NQF level 6? Is that person required a specialist? Is that person regarded as a specialist rather? Because I know that one or two of the people who he basically headhunted or got into the organization were top of their field. I think one of them is a chartered accountant, if I'm not mistaken. But some of them, were they really specialists? I think that's my question here, Chair. That's what I would like to know. If we do have their CVs, and if we do know what makes them specialists, why were they regarded as specialists? And for us to sit here and speak about specialists who were recruited, were these people actually specialists? Thank you, Chair.
Thanks very much, Honorable Kubeka. So I think you are highlighting something we need to possibly write better in the report, and this feedback is useful. So there were just a few of these people. So, and there were different issues with them. So, for instance, with Mr. Sifutle Modiba, there was no due diligence, and the Road Accident Fund appeared to not know the circumstances of his departure from the city of Johannesburg. If you recall, we then wrote a letter to the city of Johannesburg to just do the simple inquiry that the Road Accident Fund should have done prior to hiring Mr. Modiba. And we found that he resigned prior to the completion of the disciplinary process, even though he's got a different view. But we had a letter from the Road Accident Fund. If I recall, he had said he's going to send us a settlement letter. We never got it of a settlement. So the only version we have is that. So before you even get to defining what a specialist is, there were issues with the method of recruitment. The second one was Ms. Mabusela, if you remember. Ms. Mabusela is the chief financial officer who had no idea what the Accounting Standards Board does. And the board members did not know who she was because they had not seen her. And that was the second thing. The third thing is that she is the one who also initiated the process of changing the accounting policy, which has led to so many other difficulties, such as adverse audit findings for the Road Accident Fund and misrepresentation of information, etc., etc. Of course, there was also the Mr. Msiza himself. Mr. Lihumu and Mr. Msiza's qualifications, if you remember, they are chalk and cheese. Mr. Lihumu is a postgraduate twice. Mr. Msiza is not. And what happened, in fact, was that the specialists became a parallel structure to the executive committee and started taking decisions, including leading to the suspension of the incumbents themselves. So I think, and then the last thing, maybe more directly to your point, is that these organizations were not in the structure. These roles were not in the structure themselves. And so it's also difficult for us to even determine what a specialist really is, apart from somebody who was needed by the chief executive at the time to perform certain functions as they saw fit under the circumstances. But what we could observe objectively is that the specialists later went on to replace the incumbents. Mr. Msiza replaced Mr. Lihum. Ms. Mabusela replaced Mr. Songer, and so on and so forth. And that on its own creates serious governance problems. So I think you are raising issues that we have to express more clearly in the report so that when we make recommendations, the recommendations are comprehensive as well. So thank you for raising that. It kind of made me think of things that we could have surfaced differently in the draft itself. Honorable Skosan.
No, thank you very much, Chair, and good afternoon. Yeah, no, we want to again welcome this part of the report from our technical team, which is quite comprehensive. I'm happy with the manner they were able to cover all the issues that relate to this particular section. As much as it wasn't our intention to deal with labor-related matters as this particular committee. However, some of these issues are also interlinked to matters of the resources, public funds of the RAF, public funds that the RAF is using to run its businesses. Because I mean, if people are just dismissed without following proper processes, then they go to court, and then RAF use public funds against those people in a court of law, and some of them end up winning those cases that they should be reinstated, then they are not reinstated, and all those things. Now, public funds are in the main used in those particular battles. So I think we find ourselves here because of that issue. As much as it was not our intention to find ourselves dealing with these individual litigations that relates to matters of human resource, labor, and all that. So the state of RAF, it's a very sad state, or it was a very sad state at a time. We don't know whether there's an improvement or what in relation to these particular matters of employee relations and stuff like that. The fact that the CEO, the former CEO, Mr. Letswalo, would every time go and take people that he used to work with in other entities and bring them to the RAF, even when they don't qualify to occupy some of the position. And if they don't qualify to occupy those positions, the requirements of such positions will be changed. They will be tailor-made to suit an individual that used to work with Mr. Letswalo in another entity. And then if there's an incumbent or there's somebody acting and who qualifies, then that person would either be demoted or that person will be suspended, so as to give a way for the person that Mr. Letswalo wants to come and occupy a position. So this thing of headhunting, it will be done even where it's not supposed to be done, even where the policy doesn't allow. So it's a very sad state. Even the issue of people who are being parachuted to act in positions that are two steps above them. The case in point of Ms. Potgieter, who was then appointed to be an acting CFO and ultimately CFO, when the policy did not allow her to can act because she was two steps below the position of the CFO. And the person people who were qualifying to act were those people who were one step below that particular position. So those are the practices, Chair, that we have heard about during the inquiry. The issue of having some of the positions which people who are occupying those positions could not even explain what is their role. The issue of Mr. Modiba, for instance, the case in point, who was occupying the position of a CIO, who could not explain exactly what is his role and how is this role different from an ordinary financial manager or head of finance and all that. And all these people are people who were told they've been headhunted and all that. And the issue of running disciplinary processes at sometimes without the involvement of immediate supervisors of those particular employees, because in terms of their policy, if the entity want to discipline somebody, the immediate supervisor of that particular person should also be involved. So we've heard that there were instances where people were being called to disciplinary process or were suspended, but without the involvement of their immediate supervisor. I think the most popular case is the one of claim handlers, where a number of people were just suspended en masse, and then those processes were being conducted without the involvement of their immediate supervisors. Even the person who was the manager for ER tried to warn against that particular conduct. However, the CEO, the then CEO, Mr. Leswalo, insisted that those people should be suspended and all that. So I think it's a very sad story when we were dealing with matters that relate to ER disciplinary processes that involves employees. And I think there's a lady, it's just that I don't have my notes. I don't know whether it's Miss Mate, I think, who related very sad stories of people who, after being suspended or some suspended, let me say suspended without following proper processes. Some of them ended up being sick because of depression and all that. And we don't know, as we sit here, whether they are still alive or what. So those are very sad stories that we had to listen to during the inquiry. And the main problematic part is that finances, money is also involved in those processes. And what is even more sad is that even others, even after going to court without money, using their last penny to go and fight for themselves, to go and prove themselves in a court of law, even after they have won those cases, they were not reinstated. That's very, very, very sad. So I think we will have to put very firm recommendations as to how this institution that is so important to us and to the public, how is it supposed to be run from now moving forward? And we will have to do continuous oversight and monitoring to make sure that this kind of abuse of power, kind of abuse of system that we've seen under the leadership of Mr. Collins Leswalo, it doesn't happen again. So I really appreciate the manner in which our technical team was able to craft this report and make it to be so comprehensive to reflect on all these particular weaknesses. No, thank you very much, Chair.
Thank you very much, Honorable Skosana. That's very well noted, and we'll build those comments into how we think about the final draft and the recommendations. Honorable Neil May.
Good afternoon, Chairperson, and to my colleagues. And once again, Ms. Ibrahim, a very comprehensive and well-covered report. Chairperson, it is a very painful story of the RAF, specifically with regards to the HR issues, from mandate to meltdown. I mean, if you look at it in that way. Mr. Leswalo, he captured his mandate. He had a total disregard for compliance, for the law. He manipulated the employment structures and employed specialists. He had no security clearance. He undermined those current managers. he had parallel structures. And of course, obviously, he brought with him people that had worked with him previously. I mean, so that basically looks at the leadership, typical case where leadership fails. Chair, it was highlighted the acting positions that were there, but the most painful part, I think, in this whole process is the use of external lawyers. And I would say the worst part, and that was for labor cases. I think nobody had a chance in hell because he had the money, and those that were his victims had to struggle to actually get any kind of legal access or satisfaction within the law. I think the wellness report clearly stated the conditions of staff at RAF. The abuse of power by the CEO, I think, is very clear. And I think that actually one needs to maybe in future look at some kind of check and balance where one can quickly pick up where a CEO is abusing his power. He captured his board, he captured the chairperson, and then on top of that, lying to Parliament, which is a very serious matter. So I think you know, in all the testimony that we have heard, I think this is a clear case of if you had to put a title for a story on the RAF, it would be Mandate to Meltdown, a sad story with regards to the RAF. And I think going forward, Chair, our report really needs to highlight these particular areas. I mean, these are human beings that have been dedicated for many years working at RAF. There were managers. We talked about the specialist, but as my colleague was saying, what is a specialist? You know, there were specialists. I think we hear where CEOs suddenly decide no, they want their own specialist. But what about those that are there, that were there and were specialists in their fields? I mean, you looked at the department with actuaries that was brought down to a minimum, you know, with the head of the treasury and finance not even having actuarial qualifications. So, Chairperson, I think it was a very detailed and comprehensive report, and I must say, a very painful story with regards to the lives of those that were destroyed. With regards to the criminal charges, I think from myself, I am fully behind the criminal charges, and I think I look forward to seeing the outcome of that. Thank you, Chair.
Thank you very much, honorable members. We'll certainly, the team will certainly take all of those comments into account. We are in the background working with the portfolio committee on COCTA to just finalize our calendar for the rest of this month, and when we return from the September recess as well. For example, the portfolio committee, the city of eThekwini is supposed to come back and engage with the two committees again. So I am liaising with Honorable Dr. Mkhize to make sure that happens, because there were some outstanding issues therein. We will be distributing, for instance, an update on the municipal issue, because in that joint meeting, we had asked for an update that has arrived, I think, this morning, and it will be going out to members. But more importantly, as far as today's conversation is concerned, is the completion of the draft process. We right at the tail end now, and also a setting out then of the process going forward. Let me remind members that we must then send the portions that are relevant to various people so that they can make further representations. But part of what needs to happen now is to have a single document that captures all the comments of the members as a final draft, but then there will be a section on recommendations. So we need a session to go through the recommendations, taking account of everybody's comments so far, so that we can send everything to the people that have got to comment, so that it's not just the findings, but the recommendations that they comment on, and then they come back to us. Ideally, we should be able to give them the September recess as an opportunity for them to come back to us, so that when we come back, we finalize the report in the back end of September. I'm sorry to put pressure on the team. So I am going to have a meeting with the legal team and the secretary just to work through our calendar and also the calendar of this issue. We must also, we will be making time to process our oversight reports. There are quite a few, and some I believe have been distributed. So we're also going to make time so that in the final stretch of Parliament this year, we put through a whole bunch of reports, not just this one, as an outcome of the work that we have been doing. I am also remembering that I've also not forgotten what we said, Honorable Madlala, for instance, yesterday, that we get an update on what actions have been taken. The last point I want to say is two issues I want to raise with the committee as issues that are in the background. The first one is I am in communication with the Minister of Transport with regards to PRASA, because you will recall that when we had our engagement in March, there had been some serious outstanding issues that they needed to come back to us on. There was an issue of the forensic report that we had been informed is with the minister, is going to be sent to the minister for consideration. We have never received an update thereon. There were concerns raised by the Auditor General in respect of some of the procurement, the general overhaul, as well as the signaling contract. We didn't get an update on that. It's important that we clear those issues ahead of the next audit report by the Auditor General at the end of the financial year. I just have to say that the matters that we had been dealing with are still quite serious. So we must just be on the lookout for the next phase of the conversation on that. So there's the issue of PRASA then, and then there's the issue of the Public Investment Corporation. So I had been in contact with the chairperson of the Portfolio Committee on Finance. I had also been asked by the speaker on whether there should be an ad hoc committee. I had indicated to the speaker that my view is that the two committees should work together. The Finance Committee and the Standing Committee on Public Accounts should work together to work through the issues at the PIC. I had shared this view with the Finance Committee chair. It was in agreement with that approach. I also informed the finance minister that that's my view, and he was in agreement with that approach. The speaker has then left the matter for coordination to the chair of chairs. But there have been lots of developments in between, as you have seen. There is a new board there. My view is that we just determine what is sufficient time for them to settle, and then at the time, because the Auditor General is also busy with an audit, that soon after the Auditor General reports to us, we are able to call them in and to schedule a proper session. And I would propose that we look at a long session rather than a short one, so that we can deal with some of the matters in the context of the audit outcomes and the calendar looks like. But we will update the committee at the earliest available opportunity. Honorable Beasley.
Thank you, Chair. Can you just confirm if Enquiry is coming on Tuesday? And I also sent you some questions that I would have liked to have asked, and I never got any feedback on that. So I just want to know if those questions have found expression. And then thirdly, in terms of sorry, do you want to answer or should I just finish? Sorry, Chair.
No, just go on. I've just remembered that I was supposed to say to you they have found expression. It's one of the things they're coming back to account on.
Yeah. Thank you, Chair. You know this matter is particularly close to me because I come from eThekwini. And also the SIU. I mean, it's going to be interesting. I submitted a new private members bill about blacklisting today. And it's just bizarre that 1 out of 467 SIU recommendations have actually been implemented. It's actually, yeah, I'll use the word pathetic. It is pathetic. And I think that's great. But I think somebody mentioned earlier that we've got to be careful that we don't become a toothless committee, you know, and we do have certain powers and we must exercise those powers. And then in terms of the PIC, Chair, are you mentioning ad hoc inquiry or a meeting to determine if an ad hoc inquiry? So maybe if you can just
clarify that.
Yeah, and then on a positive note, I'll be able to attend 2 committee meetings at the same time. So my attendance,
and be marked present for both.
Yeah. Thank you.
Let me start with the City of eThekwini. You know, thanks for the inputs. They partly informed. I mean, we had our own queries. Honorable Madlala had further queries. I had further queries. Honorable Dr. Mkhize had further queries. Particularly because the documents they sent through did not adequately address the issues raised in any case. So we're calling them back. They will be back on Tuesday, and it will be a joint sitting. We're just working out the logistics between Honorable Dr. Mkhize and our respective secretariats to make sure the session fulfills the purpose that we need to. So that is the one thing. The second one has to do with the PIC. Now, there had been a request to the Speaker from the President of the UDM, General Bandulu Misa, for an ad hoc committee to be formed. I then proposed to the Speaker that I agree that an inquiry into the affairs of the PIC is necessary, but the form that takes becomes a joint inquiry between the Finance Portfolio Committee, Standing Committee on Finance, as well as a Standing Committee on Public Accounts, because the 2 committees are ordinarily seized with the matters at the PIC anyway, because it might be difficult for people who don't ordinarily deal with those matters to catch up, and also the time to set up might take longer than usual if the people are unfamiliar with the issues that are being dealt with there. So the matter is now with the chair of chairs. I have not heard from him, but I'm sure we will be hearing from him shortly. So I am hoping that has addressed the issue. And then lastly, we've also been in touch with the SIU. So part of the reason we've got an all-day session with the SIU is not just about the referrals. It's also about being very specific about consequences for people. One of the issues that's pertinent that we need to insist on, especially even in the context of municipalities, if you recall, is that we get proclamations for the SIU for lifestyle audits specifically, because part of what happens is that people, while the referrals to the NPA and everybody else then sit with those bodies, the SIU would be able to perform lifestyle audits, and we as Parliament are able to ask those bodies to act immediately. When we deal with the matters at PRASA, you will also see that there are instances where those lifestyle audits would be very, very helpful to the committee beyond what we are able to do right now. But I also want to ask the members that we look at the reports and the recommendations therein, and where we need to put in a lot more bite in those reports, then we need to do that. And certainly in the context of the Road Accident Fund itself and the municipalities, we must look at the whole thing, not just disciplinary action, financial recoveries, reporting to various law enforcement agencies, and also when necessary, where suppliers and the like are concerned, a recommendation for blacklisting, which we then follow up. So, honorable members, thank you very much. It's been a longish day for an online meeting. I appreciate your participation. Like I said, I'm going to have a discussion with the Secretariat, and then we are going to come back with a revised program that takes into account all of these matters that we're talking about, including the way forward on this matter of the Road Accident Fund. So thank you very much. We can adjourn.
Thank you, Chair.
Thank you.
Thank
Thanks, Chair.
you.
Thank you.